For pronouncement of judgment, item 1, criminal appeal jail 12 of 25. The matter is pertaining to IGL bench.
The appeal is dismissed.
Oblige.
Oblige.
Adjournment request, if any, from item number 1 to 5. From item number 6 to 20.
Can't hear you.
I beg to mention item number 8, Lordship with matter may be adjourned for the day. Arguing counsel Mr. J.I. will be some personal difficulty to the law. Any day next week. Lordship.
You are for the,
I'm for the appellant, Lordship.
as prayed for on behalf of the appellant. And have you informed the other side?
Yes, Lordship, I have informed the
After obtaining consent from the counsel for the respondent. The matter is adjourned to. Don't it?
24th April.
obliging.
May please, Your Lordship. I beg to mention for adjournment of item number 25, madam. Item number 25. Due to my personal problem, Your Lordship. So whether we take any other day, but as Your Lordship. 25.
As prayed for on behalf of the appellant, re-notify.
Master Lord.
Have you informed the other side?
29th April.
Already informed.
29th April.
Yeah, Your Lordship. Lordship, beg to mention item number 10, Your Lordship. Here we mistakenly failed to annex some vital or relevant documents with this petition, Your Lordship. So, Lordship, Lordship may allow to bring on records all these things by filing additional efficacy, Your Lordship. And fix a, with due respect, fix a short date before 10, because in 10, Your Lordship, my property is going to be auction that has been fixed, Your Lordship, before 10, Your Lordship, with due
As
respect.
prayed for on behalf of the petitioner, re-notify on. Oh, I love it. Yeah, this guy. On 6th of March.
Deeply obliged, Lordship.
May please, Your Lordship. Lordship, with regard to item number 31 and 32, Your Lordship. I'm paying for some accommodation for today, Your Lordship.
31 and 32.
Yes, Lord.
Adjournment slip has been circulated.
Much obliged, Lord.
May I plead the Lordship? Item number 29, Lordship. Adjournment is already.
5th May.
Obliged.
Blood.
7 May. 29th, 7 May.
Lordship, with regard to item number 20, Your Lordship, we have filed two affidavits, Your Lordship. We have served advance copy upon the respondent's Lordship. May I pay the same may be brought on record, Your Lord.
Item number 5.
At number 20.
20, Your Lord.
Any other request?
Lord, this is a writ appeal regarding selection and appointment to the post of principal. This matter may come up on 17th of March, Lord. There is an urgency, Milord.
17th of March, why do you say?
Milord.
Why?
Since
17th
after
of-
Holi,
What's
after-
so special? All right, 17th of March.
most obliged.
AC बंद करो भाई.
Daily list for orders, item 1.
Service, no?
Lord, in this case, my learned friend put appearance, Lord.
Lord, I am appearing on instruction in mother for respondent number 1A, 1B, and 1C, mother. Both the IA, mother.
You are appearing for respondent numbers?
1A, 1B, and 1C, mother.
At page 11, Your Lordship.
11, mother.
Impleadment?
Mother.
The allegation stands alone. They are impeded. Fresh memo of parties to be filed.
My Lord, there are other opposite parties. We have to wait. There are other opposite parties also.
Let's see. First, we have
All right.
disposing of this IA.
Lord.
Then other issues will come. Where's the right?
24th April.
Oh, Lord. Yes.
Supplementary, item 33.
Orders. Number 3. Awaiting the service of notice.
I'm for respond number 2.
Awaiting the service of notice on respondent number 3, the matter is adjourned to over date.
29 April. Item 2 for admission.
An affidavit has been filed by the respondent number 5, Your Lordship. And Your Lordship may kindly go through the page 109 and XRA, Your Lordship. There's a report of the circle officer, Your Lordship,
Affidavit?
filed by the respondent number 5, Your Lordship.
Page
Additional
109.
Page 109.
Nothing can be done, Mr.
No, Your Lordship will kindly see the para 2 and 3. We are not on your
Forget about paras 2 and 3.
Lordship.
We have looked at paras 8 and 9.
No, Your Lordship.
There is
the-
no dispute with respect to the fact that the school falls under the jurisdiction of Dahikata Forest.
Lordship. No, your Lordship may kindly
Remain there.
for a moment come to page 109, Your Lordship. I am not that, Your Lordship, that school should be there, but the problem we have faced has been admitted by the circle officer. That's the issue, Your
What
Lordship.
is,
That is why we have before this honorable court.
what is this page 109?
109 is a report by the circle officer, Your Lordship.
What does he say?
It says, Your Lordship will kindly come to para, from the first paragraph I am reading. The Luptosar LP school was established for the first time in the year 1947 and which was situated at village Devapara, Luptosar, and due to havoc created by the devastating flood, erosion of Jaljali River, the said school premises was eroded and subsequently it was shipped to the south side of the river to village Bhatlipara and Desbhuja Devosthan Revenue Village under Matia Revenue Circle. First of all, Your Lordship may note that Revenue Village, Your Lordship. I found 292 numbers of students who studied at Luptosar LP School, Desabhuja Devosthan, and 548 numbers of students were there in ME section and 356 numbers students are there in the high school section. And by calculating, it found 904 numbers of students total are there already studying in Surjaguri ME school, where 8 numbers of classrooms are not sufficient for smooth functioning. Then, Your Lordship, due to the shifting of Luptosar LP school, total number of students of so-and-so school has rose to 1196, consequence to which heavy congestion has appeared on the State Highway 46, and it has also no sufficient infrastructure for study of 1196 numbers of students, and there is no proper provision for sufficient urinals, toilets in the shifted school. The Luptosar LP school, Desabhuja Devosthan, possessed a plot of land measuring so-and-so bigha by RF Dagnam.
Mr. Bhattakur,
Lordship.
you are referring to page 109.
Lordship.
This has been taken note of in paragraphs 8. and
Yes, Your
9
Lordship.
of the affidavit at page 106
Lordship.
and 107,
Lordship.
105 and 106.
Lordship.
So I think nothing more is to be done. The department will move for sanctioning of additional classrooms for Sri Suryagiri ME school.
Now, Your Lordship will kindly see Your Lordship, that's a statement made by them. Your Lordship, for since 11th November 2025 till date, Your Lordship, they have not moved for that, Your
Mr.
Lordship.
Swami, what is the follow-up action?
I'm actually appearing for the forest department, my lord. Our name should
Forest department. Who appears for the education department?
their own selling of singer.
Mr. Talukdar, don't wait for the court to point out.
Correct.
You must come up yourself, no?
Correct.
Paragraph 9 of your affidavit at page 106. You're not aware of it?
File by one.
Any one of you. We will not be able to point out sitting here who has to respond.
My lord.
You have to tell us, no?
Correct. Lordship will kindly give 1 week time, my lord. I'll get back to you, Lordship. In this, my lord, on this point, my lord. Lordship may make an observation, my lord. I'll get back with concrete.
Take that. This writ petition, this PIL
No, how to hack it.
has been filed challenging the decision of the respondent authorities in relocating the Luktachar Lower Primary School, Lower Primary bracket LP school from its original place to somewhere else for the reason of the school building being situated inside Dahikata Reserve Forest, notified in the year 1973. The inspections made by the authorities, made by both the authorities, made by Forest and Education Authority, confirm that the school in question was located in a reserve forest, which is impermissible. Precisely for this reason, a decision was taken to shift the school to Dashbhuja Devasthan and attach the school for the time being to Sri Suryagiri ME School. However, Mr. Borthakur, learned advocate for the petitioner, points out that with the the school in question being amalgamated to Sri Suryagiri ME School, students are finding it difficult to attend classes because of lesser number of classrooms, and already many students enrolled in Sri Suryagiri Middle School, ME School. The affidavit filed on behalf of the Education Department,
Deputy Commissioner.
the affidavit filed on behalf of the Deputy Commissioner, where Deputy Commissioner, the affidavits don't state what.
District Commissioner.
What is this? What is it? No, what did I say? The affidavit filed on behalf of respondent number 5 indicates that shortly the Department of Education will move for sanctioning of additional classroom to ease out the situation. Mr. Borthakur submits that till date, the file has not moved for sanctioning of construction of additional classrooms so as to accommodate the students of the school in question. Mr. Talukdar shall take instructions on this aspect of the matter and shall inform this court on the next day. Re-notify 2 weeks.
20th March.
Deeply obliged.
Yes. Item 3 and 4.
Item 3 and 4, my lord, may kindly take up this matter after some time, lord.
After some time is something which is not possible. We have many other matters. We have others. Oh, Lord. We have passed some orders. Take minute. Well, that's one thing, but now let's decide this now. Join the board. You're ready?
Yeah,
And what do you have to say?
lordship, may kindly Lordship, item number 7.
That is all right, but it's the thing on this. Assessment is very short.
There is a minutes of meeting, Lordship, by the rule committee, Lordship.
That's all right.
And rule
Rules-
committee, Lordship.
Rules is all right. That is with respect to the second case and the observations
Lordship,
by the learned single year.
Kindly,
We are testing the correctness of the judgment so far as Jayanta Bora is concerned. His application was rejected, his writ petition was rejected. He says that the post is that of the post of accountant is that of our upper division assistant or something.
Lordship.
And therefore, if it is the
No,
same,
he was
it has the same
accountant.
salary, but the law remains very clear, undiluted up till now in service jurisprudence. Encadrement is necessary. So I think you have a strong point there, but yes, you argue, we will deal with your petition today.
And Lordship, may take
Yes, sir, you argue.
after some time, Lordship. After some time, Lord.
The next order. And the petitioner, he was appointed as the LD assistant in the year 1919 in the establishment of the judicial magistrate Mongol. And 1919, when Udalguri subdivision was created, he was transferred to Udalguri, madam. Since then, he was working there till 2012 as LD assistant. In the 2007, for the three districts, Udalguri, Baksa, and Sirang, for three districts, two posts of accountant, one in establishment of the judicial magistrate, one in the establishment of district judge, was created by the government, my lord. So the petitioner, he was the senior most LD assistant. That is why he was promoted to the post of accountant in 2012, my lord, which is the federal post of the upper division assistant, my lord. In the year 2000,
Those facts are known to us. You tell us, where has the learned single judge gone wrong?
main point, my lord. Main point, my lord, the upper division
Who
assistant.
appeals in the next matter?
Upper division assistant and LDS accountant, both have same career post. That has been clarified by the government also. The government by
Doesn't matter.
The
There
government
has
has
to be
highlighted
an
it.
encadrement.
Is
The determinative factor always is the cadre structure and recruitment rules. Only similarity of pay or approval for some reason or the other, that doesn't function. Creation of cadre, prescription of rules, these are purely in the domain of the rule-making authority. Clear? There is no difficulty about the law. So that way you lose out, Mr. Jayanta Bora. Somebody, the respondent has been appointed, he has been appointed rightly. The court took notice of that fact. That was also not trivial. Article 229 of the Constitution does not permit. If approval has to be taken, approval is required to be taken. Without that, but considering out of the two evils, I think that out of doctrine of necessity, it has been done. We can't possibly do that. I don't know whether you are following what the court is telling you, Mr. Sharma.
on the point of which the petitioner, my petitioner rejected, is the according to learned single judge, that post was not catered.
That is the point which we are, which
account-
caught on to.
Accountant was not
Sir,
anchored.
that is the point which we have caught on to. You have to show us by any law or anything. We, as far as the service jurisprudence is concerned, we are very clear about it. There cannot be an interference on that count. It has been unfair to you because you moved in a different trajectory. You became an accountant. Now they have to say, they have to encadre, they have to make the rules. Unless that rules are made, you are automatically shut out. That is what Manjusri says. That is what all judgments in different
It
fields.
was not encountered in the some judicial establishment rule. Encadrement is not my duty. It is the duty of the government. The government has created the
not
post.
your duty.
And they have
We
to encadre
understand,
it,
but
my
in
lord.
the absence of encadrement,
Moreover, I was not given any, I was not told.
you don't fall in the pool.
At the time of my promotion to the post of accountant, I was not told that.
Mr.
That is my last. I cannot expect promotion in future, my lord. I was not told.
I cannot-
Because it is the escalator post.
There's some difficulty. Doesn't care.
Yes, that is, my lord, if the encampment is not done by the government, because of that, I cannot suffer. I am the synonymous accountant. It is the equivalent to accountant, my lord. So I should have been given promotion. But the private respondent has been promoted by condoning age, my lord. 5 years, he was promoted in 19.
We have said all this. Did you not? We are telling him, Mr. Das, you have to make him understand.
Yes.
We have heard him. See, this man was an accountant. Previously, he had applied. I mean, why am I telling you? It's
No,
only for
government
him to hear.
I understand. my lord. I understand.
You know the fact of the
I
case.
understand.
He was an accountant. Now, when that post of head assistant fell vacant, there are rules which say that he has to have some years of experience, 10 years of experience as upper division assistant. Nobody could do that. Later, the judicial establishment reduced it to 5 years. So that is the only question which he can raise. The question is that if that reduction in the prescription would not have been done, then perhaps he would have made it, and he would otherwise not have made it for the reason that he does not fall in that pool. Same pay, same structure, same function does not matter so far as the rules are concerned.
Correct.
Now he has to be encadered. Fault is not him, but fault lies somewhere else, and therefore the learned single judge was very right in suggesting that the rules ought to be
My lord, in
changed.
fact, the learned single judge, my lord, if your lordship, they have annexed the order sheets. Lordship will appreciate how much pain the learned single judge had taken to, my lord,
And number one, now
get a solution.
he has to be made to understand that suppose the reduction in the prescription of 10 years, if that reduction does not have the sanction of law, but who can challenge it? A person who would otherwise become eligible.
Correct.
So does he become eligible even by questioning that? So why do we disturb? That is the legal question which he needs to answer.
Yes. My lord, may I just pray one thing, my lord? There is another matter which is also, my lord, connected to this, my lord. No. Why I'm saying so, my lord? Lordship can take up along all the three matters together in another day. I'll enlighten my senior, my lord.
Yes.
In the meantime.
There has to be a conversation, no? Otherwise, I pass an order, he'll not be satisfied.
I understand.
See, lawyers don't get satisfied either ways, but then it must be, the observations of the bench must be communicated.
Correct, my lord.
That is how I have functioned in my court.
And that is always, my lord, happening here, my lord.
But
That is always happening here.
I have seen, and that is the way that is the practice which I follow.
Correct, my lord.
So judgment is in our hands, we will decide.
Yes.
But then not without giving the reasons to the advocates. What is this institution meant for?
True, my lord.
It's not my sweet will.
True.
So therefore, the thing which we see,
Yes, my lord.
is this, that appointment of the respondent also is not fully, within the parameters of law, because this reduction was not without an approval. It was without an approval.
Yes.
So Article 229 comes into play.
Yes.
But question is that this appointment can be questioned by a person who would be eligible if this reduction is disturbed.
Correct.
He is not. Number one. Number two, because he is not because of any lack of experience, but not as an encaded experience.
In fact, learned single judge also, my lord, tried his best, my lord. Tried his best to come to a conclusion, my lord. Different instructions, different time was sought from the government.
The only other option would have had been for the learned single judge to have scrapped all such appointment directed for change in the rules and then go for
Exactly.
selection. But that would
That's why last paragraph of the impugned judgment.
disturb the entire, working pattern.
Yes, that's why.
So therefore, this we can justify on doctrine of necessity. The institution had to run.
Yes.
But he doesn't fall in the picture. What is the other case apart from these two? Then it goes
retaping number 21. Serial number. The day before yesterday, your lordships condoned the delay and directed for listing of the writ appeal.
When?
Day before yesterday. I'm just giving the
22nd April.
All right.
27 April.
27th of April. So all these matters go to 27th of April. Mr. Sharma, come prepared.
No, it
My,
is-
your,
it is-
your
that
colleague
is
will
also-
tell you.
That is different thing. It is also different case. My lord.
Are you agreeable for all the three matters to be taken up together on
22nd, 2nd of April.
22 তারিখে 22 এপ্রিলৰ আৰু এটা মেটাৰ পিছতে একেলগে ৰাখিব খুজিছো।
But it will be too long, my lord, because the
Other matter is appealing matter to.
I believe you have been a
That's up to
judicial,
your lordship.
I believe you have been a judicial officer.
If your lordship take this case with other case,
कोई और
that's up
बात
to your
कर रहे
lordship.
हैं वकील साहब। I
27
believe- I think that you have been a judicial officer.
Yeah.
Huh?
That case.
Let,
No, it is 27
Yes,
for
I am retired.
27 for 26. 27 for.
this court has been informed that another appeal arising out of the same judgment has been directed to be listed on 27/4/2024. Give the number of that appeal.
Milord, yes, I'll give the number, serial number.
Let these two cases be listed with the aforementioned appeal on 27/4. Number to be provided by Mr. Das.
I'll provide me.
His appointment was set aside by the learned single judge, but he is still continuing according to the information.
Let's see on 27.
Item number 5.
May please, Lordship. This is a writ appeal, Lordship, hereby notification 56 of 23 has been set aside by the learned single judge on the ground that it is ultrate to section 68. Lordship, in the meantime, the same notification is pending before the Honorable Supreme Court to decide. And given the copy, Lordship.
That's all right, but as of now,
Lordship. As of now, it is pending.
we find substance in the judgment of the learned single judge. Because
Lordship.
these, in fiscal law, limitation has to be very strictly construed.
Lordship, here, the learned single judge held
Anyway,
that there was no-
as prayed for by Mr. Yeah, I pray as prayed for by Mr. K, learned advocate for the appellant / Central Board of Indirect Taxes. Let this matter come up for consideration. March?
Lordship, Lordship, may propose that the appeal may be admitted and may be posted after Supreme Court decide the matter. Lord.
In March. That time you decide. If it is decided, these are fiscal matters. With the judgment passed by the learned single judge, the entire, decision with respect to those frauds, 7510, that
Lord.
decision, that goes. Now, this extension therefore was not applicable, and otherwise the limitation period runs. The two things which are necessary, these are not, just persuasive value. The GST Council had to
Lordship.
sanction. And number two, the force majeure had the proximity with the year where the time is being taken. All right, what matter is the Supreme Court will see it after that.
Lord.
23rd March. Item 6.
This appeal preferred by Union of India, my lord,
Yes.
against the judgment dated, my lord, 22/7/2025. The respondent, my lord, is a constable in BSF. First, after a summary security force court trial, my lord, he was dismissed from service. Now, my lord, allowing the requisition, my lord, the learned single judge only because of only one point that during the summary security force court trial, my lord, the commandant who was the presiding officer, he also acted as an interpreter. But that was done, my lord, as per the rule. Rule 134(2) is there. That in their repetition also they have in para 14 they have mentioned this issue, my lord. We have replied in our affidavit in opposition para 15. That plea has been taken. And denying that plea mainly because of that, because he pleaded guilty out of 4 such 3 such he pleaded guilty. Charges were there, my lord, pointing.
Yes, you're appearing, Mr. Goswami.
Yes, my lord. I'm appearing for the respondent.
Okay, yes.
I need 2 weeks time to file affidavit. in
You
court.
just keep standing like that, and when the court was about to pass an order, you say that you want time.
My lord, also my senior's name has not been reflected in the cause list. So,
ये पहले बोलना है ना?
जी, we started the,
हाँ जी?
he has started, so I
He has
not-
started, but you could have
I could
taken
not
the leave of
interfere
it
as
and said that you want time. Your senior is not here, your name was not reflected in the cause list. All these things you must say. Why do we hear? Why do we waste time? Huh? When do you want it?
after 2 weeks, my lord.
After 2 weeks.
Yes.
Like here, the letter counsel for the appellant / Union of India and 3 others is present. The counsel for the respondent. Respond number?
Sole respondent.
The learned counsel for the respondent submits that he is being led by a senior in this matter who is not present today. He further submits that his name does not, his name is not reflected in the daily cause list. Let this matter come up for consideration on after 3 weeks, whichever is the date. Let the name of the counsel of the parties be reflected in the cause list henceforth.
2nd April. Item 7.
May it please your lordship. May it please your lordship.
Yes.
This writ appeal is filed against the judgment in order dated 4/5/23, passed by the learned single judge. This writ appeal actually, my lords, is the second round of writ appeal. Earlier, the division bench was moved and the matter was disposed of with liberty to file afresh if the representation was not addressed, my lords.
1 second, Mr. Goswami. 1 second. A similar matter is pending.
Yes, my lords. I have given the order, my lords.
Where is that order?
My friend would just hand over, my lords. Issue is whether, my lords, the new contributory
Operation Blackboard group, other groups.
This is it is one of the categories. This is excess appointment category. If your lordship just have a look at this review petition 275 of 25 at 28, the last 2 pages, my lord.
Let this case be listed along with review petition number 275 of 2025 on 24/3/2026.
Deeply. Your lordship would not consider issuing notice to the, or should we?
Let it come. We'll see. We'll see on that.
Be obliged, ma'am.
First of all, we'll decide the review, and only thereafter we'll do whatever we wish.
My lord. This writ appeal is because we had, if your lordship sees at 129, that liberty has been given to us to approach your lordship again.
In the meantime, let notices be issued to the respondents on steps being taken by the petitioners within a period of 3 weeks, within a period of 2 weeks, both modes returnable on the same date.
Deeply obliged, madam. Deeply obliged.
Item number 9.
Whichever government council can accept notice, you can state.
As your lordship so pleases.
Standing council, it will declare.
Well, they'll do it, madam. Deeply obliged.
All right, on government departments, their standing councils will accept notice to private respondents only if it is necessary. There is no private. They accept notice is accepted by so and so. Give us slips.
Yes.
Let it remain on that. You don't have to file any requisites now.
As your lordship pleases. Deeply obliged.
Item 9.
May it please your lord.
Yes.
My lord, the petitioner is aggrieved by the transfer which is issued on because of his purported misconduct. And as such, my lord, it takes the color of punishment. And as your lordship knows, my lord, punitive transfer is not permissible in the eye of law. My lord,
this is item number. Yes.
Yes. My lord, the petitioner is working as a newsreader cum translator in All India Radio and posted at Gauhati. And my lord, he was transferred on 21/7/2020. Being aggrieved, he immediately approached the Honorable Central Administrative Tribunal Gauhati bench, which, my lord, remitted the matter back to the authorities for passing a speaking order and stayed the transfer order till then. And my lord, the authorities write order dated, speaking order dated 29/2020, and upheld the transfer order, saying that there are serious allegations against me, which amounts to misconduct. That's why I have been transferred. Then again, I approached the Honorable Central Administrative Tribunal, Gauhati bench, which stayed the transfer order, and eventually the matter was heard on, my lord, this February, and on 17/2/2026, the Learned Central Administrative Tribunal, without considering this aspect of the matter, that the impugned transfer is punitive in nature, my lord, dismissed my original application. That is how I am before your lordship, my lord. Lordship will find the impugned transfer order at page, my lord, 27.
16 and page 160. This is the first round.
May I read it, my lord?
Yes, page
27 is the impugned transfer order. May I read it, my lord?
yes.
Shri so-and-so, newsreader cum translator, regional news unit air, All India Radio Gauhati, is hereby transferred along with his post, in the same capacity to RNU air Port Blair with immediate effect. My lord, agreed by this, I approached the Honorable Central Administrative Tribunal.
You straight away, you said you came before the High Court first and then you went to the tribunal.
No.
So you went to the tribunal?
Yes, ma'am.
Yes, you went to the tribunal. Then what happened?
And my lord, the tribunal passed an order that the lordship will find at page 29, my lord. The operative, it starts at page 29. The operative portion lordship will find at page 35, para 10. Page 35, para 10.
Page 35, yes.
Para 10. Therefore, at this stage, without issuing any notice to the respondents and without keeping the matter pending, I am of the considered opinion that let the respondent number 1 decide the matter in a judicious manner. For that purpose, applicant is directed to send this OA to the respondent number 1 as early as possible, but not later than 10 days from the date of receipt of this order. On receipt of the OA, the respondent number 1 shall treat the same as comprehensive representation of the applicant and consider his grounds in the OA and dispose of the same as per rules by a reasoned order and speaking order within a period of 30 days thereafter. Needless to mention that the order to be passed shall be communicated to the applicant forthwith.
Just a minute, and what grounds had you raised?
My lord, today I am raising, my lord, the impugned transfer.
What grounds had you raised? Let's see that part.
My lord, today, my lord, I am raising that the impugned transfer is on purported
Just a
misconduct.
minute. Before the OA, before the tribunal remitted the OA, could not have been done to respond number 1.
My lord.
That was a procedure which is very novel. That could not have been done. But nonetheless, what were the grounds raised in that OA?
My lord, I have assailed the OA.
Just a minute, show us from the observations made
Yes.
in that
Yes.
order.
Yes, my lord. Lordship will kindly come to page 31, para 3. Page 31, para 3, my lord. May I read it, my lord?
No, that is not what we are looking for. Para 6, during pandemic and release order with the direction of the people. All right. So thereafter, what happened?
Thereafter, my lord, this honorable tribunals limited the matter back to the authorities and in the meantime stayed the transfer order, my lord. Then the speaking order as per these honorable tribunals that your lordship will find at page 40.
Page?
40.
Yes.
Lordship will kindly to turn to page 48, next page, para 4. May I read it, my lord? And whereas while posted at RNU Gauhati, several complaints were, none of the complaints has been served to me till date. Several complaints were received against the applicant on various issues, including poor performance while discharging his duties of news reading, unauthorized absence from the office, assigning his work to other employees, misbehaving with his senior and fellow employees, sending emails to Director General directly, misinforming about the organization and not adhering to the rules and regulations.
Now we are concerned with paragraph 6 and paragraph 7. Now then what happens?
Then, my lord, assailing the speaking order, I again approached the Honorable Central Administrative Tribunal, Gauhati bench, my lord, and the Honorable Tribunal, by interim order, my lord, stays the operation of the speaking order. That interim order, lordship will find at page 85.
Yes.
That it starts at page 85 and the relevant portion at page, my lord, 86. Lordship will kindly turn to page 86. In the middle, I have heard, have your lordship got it? Just in the middle, I have heard both the learned counsel.
Which paragraph here, sir?
Page 86, my lord. The penultimate para at page 86. I have heard both the counsel. Has your lordship got it?
So interim order was passed. Then?
Yes, my lord. Thereafter, my lord, in view of this interim order, the respondents, my lord, though they have released, they allowed me to walk. That your lordship will find at page
That
80.
doesn't matter. Now what happens?
That is has a bearing, my lord, page 88.
That cannot have any bearing. In fact, we are finding the entire procedure to be very amusing.
Yes, my lord.
The tribunal was supposed to decide the OA. The OA cannot be sent to the respondent authority. A member of the CAT cannot make another person a tribunal.
True, my lord. But the authorities.
If at all the tribunal was inclined to do that,
yes,
it could have directed you to file a representation and not send the OA. But we don't know what is this procedure.
And my lord, the authorities did not approach against that order.
All right, then what happens?
And then, my lord, eventually the OS came before the learned Central Administrative Tribunal, and the tribunal, by the order dated 17/2/2026, dismissed it, my lord, without taking into consideration that
where is that?
Yes, lordship, the interim order starts at page 178. The relevant portion is page 185, my lord. Page 185. May I read it, my lord? In the present case, page 185. Last two pages of the petition. Page 185. In the present case, there is no violation of any statutory provision in transferring the applicant, nor any malafide is proved. The court cannot interfere with the administrative discretion of where an employee's services are best utilized as per so and so. This, my lord, is very important. The applicant's conduct specifically regarding newsroom discipline and the availing of medical leave without medical fitness certificate has to be found wanting by the authorities. Hello, there was no procedure adopted as admitted under Article 311. There, as persons is being called upon me that I've committed misconduct, and in lieu of that, my lord, they're transferring me as a penal consequence. That is not permissible, my lord. And this OA has been accordingly dismissed, the interim order vacated. Also, one judgment I beg to refer, my lord. Lordship will kindly permit to rely one judgment, my lord. There is a judgment of the Silpi board also, but first I would like to rely on Someshwar Tiwari, my lord. My lord, in this case, my lord,
you have remained in Gauhati for 24 years, haven't you?
Yeah, I'm a news reader in Assamese, my lord, and I have been transferred with my post to Port Blair, and Assamese news reader in Port Blair, my lord. Anyway, my lord, lordship, here in this Someshwar Tiwari's case, Mr. Tiwari was an Indian Revenue Service officer. He was serving as the Deputy Commissioner of Excise.
This doesn't apply.
No, lordship, kindly come. No, only para 16 I'm doing.
We know Shilpi Bose.
Yes, Shilpi Bose also I have brought, my lord. Para 16 lordship will kindly sign, my lord. Para 16 of the judgment.
Yes.
At page 597.
Yes.
Indisputedly, an order of transfer is an administrative order. There cannot be any doubt whatsoever that transfer, which is ordinarily an incident of service, should not be interfered with. save in cases where inter alia malafide on the part of the authority is proved. Malafide is of two kinds, one malice in fact and the second malice in law. The order in question would attract the principle of malice in law as it was not based on any factor germane for passing an order of transfer and based on irrelevant ground, that is, on allegation made against the applicant in the anonymous complaint. It is one thing to say that the employer is entitled to pass an order of transfer in administrative exigencies, but it's another thing to say that the order of transfer is passed by way or in lieu of punishment. Or in lieu of punishment, my lord. When an order of transfer is being passed in lieu of punishment, the same is liable to be being declared
Have you joined the
only.
place of posting or not? Have you joined the place of posting?
No, my
Have
lord.
you got report player?
No, it was stayed, my lord.
No, now.
Now, no, my lord. I immediately approached this honorable court. 17-2 was the order.
Please go. We are dismissing this petition. Don't be under any illusion. Heard Mr. Hazarika. You are Mr.
I'm J. Patwari, my lord.
Heard Mr. J. Patwari or Patwari?
Patwari.
Heard Mr. J. Patwari, learned advocate for the petitioner and MS
B. Sharma
B. Sharma
for 1 and 2.
for response number 1 and 2. The petitioner has questioned the judgment of the tribunal dated so and so, dated 17/2/2026, refusing to interfere with the transfer of the petitioner to Port Blair from Gauhati. The petitioner was employed as a news reader cum translator, bracket Assamese with All India Radio, a government broadcasting service under the Prasar Bharati. He was, after his appointment, transferred to the regional news unit in Gauhati in the year 2000, where he had served for about 20 years. As claimed by the petitioner, he has earned several accolades and encomiums during his tenure at Gauhati. But for malafide reasons, he claims to have been transferred in July 2020 to reader what is it called? RNU.
Regional News Unit.
To Regional News Unit Port Blair, bracket Andaman and Nicobar Islands, along with a relieving order on the next day. On the next day. The petitioner immediately approached the tribunal the Central Administrative Tribunal Gauhati against such transfer on the ground that the transfer was not on administrative reasons, but as a knee-jerk reaction to the complaints received against him. So that apart, it was also questioned on the ground of the management being insensitive to the commendable work rendered by him even during the pandemic period. The tribunal, in its wisdom, by order dated 31st of July 2020, sent the OA to respondent number 1 / Director General All India Radio, comma, a novel procedure indeed. To look into the grievances of the petitioner and pass a reasoned order within a specific time frame. So, till such time, the transfer order was stayed. A speaking order thereafter was passed by respondent number 1 on 20th of September 2020, in which, though references have been taken of various complaints regarding poor performance of the petitioner and his misbehavior with fellow employees and even seniors, but for the reasons of administrative convenience and in the interest of organization, comma, the petitioner was sought to be transferred, thus treating the OA preferred by the petitioner before the tribunal as a representation on his behalf, comma, the same was rejected. This speaking order rejecting the request of the petitioner to reconsider the decision regarding his transfer was questioned by him before the tribunal again. Where an interim order was passed, keeping the transfer order of the petitioner in abeyance. However, finally, all the OAs and the miscellaneous applications were disposed of on 17th of February 2026, holding that the reasons for transfer were administrative and for the better running of the organization. The questions raised by the petitioner before the tribunal on this occasion, namely the lack of, no evidence of there being any functional requirement behind the transfer. Bracket. As an exclusive Assamese newsroom, as an exclusive Assamese NRT, there was no functional requirement for his services in Port Blair, as there is no Assamese news unit at that station, bracket close, semicolon, and Malafites, because of his having exposed many illegal and corrupt practices committed by the Deputy Director, RNU, RNU Delhi, and the news editor / RNU Gauhati, what did I say? Beginning with no, ऊपर से उसके ऊपर the challenge I missed the link. उसके बाद लिख रहा were answered by the tribunal with respect to the plea of malafide, the tribunal was of the view that the petitioner could not establish malice in law with concrete evidence. He only raised allegations without any supporting evidence. And that the burden of proof for malafide is normally very high, and the petitioner had miserably failed to prove that. As regards the functional requirement of the transfer of the petitioner, the tribunal relied on the judgment of the Supreme Court in Union of India versus SLM 1993 for SCC 357, that the choice to transfer an employee with the appropriate authority is with the appropriate authority, unless the order of transfer is vitiated by malafides or is made in violation of any statutory provision. It is not open for the courts or the tribunal to interfere with the same. No statutory prescription was indicated by the petitioner, circumscribing the powers of respondent 1 and other appropriate authorities to transfer the petitioner after several years of his stay at one particular posting. The tribunal also rejected the claim of the petitioner and rightly so, that for the commendable services rendered by him even during pandemic period, his transfer order should not have been. His transfer was not good in the eyes of law. The Mr. Very learned advocate for the petitioner has, however, submitted that there can be no dispute with respect to the fact that an order of transfer is an administrative order, and it is ordinarily to be taken as an incidence of service which is not interfered with lightly. However, in cases where malafide on the part of the authority is proved, the transfer orders can be interfered with. He has further submitted that the discussion in the speaking order of the tribunal on an earlier occasion, rejecting his representation for such order to be reconsidered, then a discussion in the speaking order of the respondent number 1 He has further supported that the discussion in the speaking order of respondent number 1, rejecting his request for reconsidering his transfer to Port Blair, several instances of complaints against the petitioner was cited. This therefore forms the backbone. This therefore forms the motive for transferring the petitioner, which indubitably can be said to be punishment. And transfer by way of punishment is generally not ratified, is generally not validated. He has referred to the judgment of the Supreme Court in Somesh Tiwari versus Union of India and others, 2009, 2 SC 592. The administrative decision rejecting the request of the petitioner to reconsider his transfer may have taken note of, may have incorporated in the administrative order. There would have been some incorporation of factual background, but it has to be seen in the context of the necessity of transferring the petitioner, more so when there is no restriction on such transfer, and such transfer was effected after 24 years of the petitioner having served at one particular station. It is not for this court or any tribunal to assess the functionality of the transfer order or to provide the administrative authorities with a choice which would satisfy the transfer. We have all the fact that the petitioner has remained at Gauhati for long number of years before he was transferred has also weighed with us in not accepting any one of the pleas of the petitioner. For the aforenoted reasons, we find no merit in this petition, and thus we have no option but to dismiss.
Obliged then.
Item 11.
Kindly peruse the order to the 9-1. This is basically, my lord, against illegal fishing inside Kaziranga National Park, my lord. Prohibitory orders were issued, my lord. Steps were taken. My lord, then, despite that, my lord, 2 attempts were made to fish, my lord. Those were pushed back by the forest and the police authorities, those persons, and my lord, to that effect, we have registered cases.
But now the bihu is over. Another bihu is coming. Is there any practice of fishing? Is this bihu also?
No.
There have been commercial sort of, I mean, it's been of commercial proportion this time, Miller. It's reported, Miller.
That's all right. So now it's over. You see, I was somewhere near Kaziranga during bihu period, and there was a whole lot of protest. There was a whole lot of, I mean, I'm not importing my personal knowledge here, but there was a whole lot of protest, and the local persons were of the view that this is coming since times immemorial, it cannot be stopped, but every effort was being made by the police administration to restrain them. And commercial fishing absolutely out of question. That was not, there were instances of, breaking open the gate and, forcible entries.
Miller, in the old times, there were even, Miller, elephant races, Miller, during Bihu.
Sand Tribune, this
This
looks like a sporadic act of fishing for the purpose. We have tried to restrain it. What do we do? Put a noose around them, identifying them by photographs and
No, I have the photographs also, Miller. The photograph will not
Now,
mislead.
Mr. Phuket.
You know, what I'm asking for is some directions that, because this cannot be the level of enforcement, Miller. Because this cannot be the
That you
level.
shall be careful in future and let it not be a one-time affair only before due. It should not be allowed to be used for commercial fishing.
Yes, ma'am.
Otherwise, you'll be spoiling the ecological balance.
Milord, because I have
Let the
taken these
PLB allow-
photographs, Milord, just for my satisfaction, if I may hand over, Milord, because this specifies the ranges. And there was also a bird count that was happening around this time, Milord. I have also provided copies of that. Milord. And this is huge number of migratory birds which were reported.
No, that's
107 species were reported, Milord. There were a lot of them which were threatened species. There were
Let the
endangered
PLB
species.
allowed, my lord, we'll definitely follow.
Aiming at now.
So what I'm
If there were a
aiming at,
large number of birds which migrated during those periods, that means they had a good number of fishes to prey.
yes, but at the same time, you're disclosing the data that there's a huge number of species, but you're not doing enough to protect the ecology, Milord. That is something that has to be ensured, and those found to be in lapses, Milord, have to be brought to book, Milord. Well, there are two ranges which I have covered in these photographs. One is Bagori and the other one is Bura Pahar. Milord, in this report which I have provided, the water bird count, the largest number of birds are reported in these two ranges.
We have heard Mr. A. Phuket, learned advocate for the petitioner, and Mr. Ian Goswami, learned additional advocate general, Government of Assam. This PIL had been filed seeking an urgent judicial intervention to prohibit large-scale fishing in the water bodies of Kaziranga National Park and Tiger Reserve in Assam. The situation had become alarming, particularly on the eve of Bihu festival. This court had directed the local administration to prevent such commercial fishing in Kaziranga waters, keeping in mind the extreme necessity of maintaining biodiversity and saving of endangered species, especially one-horned rhinoceros and many kinds of migratory birds. Approximately 42 species of fish also was required to be protected with any commercial farming, with any commercial fishing, with stress on such fishing in large numbers by multitude during Bihu times would spoil the ecosystem, which had already become very fragile, which is already very fragile. Necessary corrective measures were taken by the district administration. But despite that, there were some isolated instances of restive crowd entering the Kaziranga premises, Kaziranga area for fishing.
Commercial fishing.
No, not commercial.
Kaziranga for fishing, which they claim to be, which they claimed as a matter of consuetudinal right. The report indicates that those instances were only few and far between and very sporadic. Mr. Phuket, learned advocate for the petitioner, however, contends that such emergent situation would arise only by the next Bihu festival. But then steps should be stepped up for preventing any commercial fishing in that area. we appreciate such concern of the petitioner and conclude this writ petition by directing that all steps shall be taken to prevent the ecological balance of the area in question, which is not only an administrative necessity, but a constitutional obligation as well. The writ petition stands closed, with the liberty to the petitioner to approach this court again in case it is found that commercial fishing has not stopped in the area. That is for you, Mr. That is to give you another platform, Mr. Pukan, which is that. And don't come with, an affidavit without any substance.
It's
For
certainly
reopening
not.
the case.
Certainly not. No, because the prohibitory orders which were issued themselves acknowledge that commercial nets were being
See,
used.
what is to be done? That interface with the people, you don't know how people behave.
The feast of a few
There
minutes.
were so voluble protests against the High Court's order, the administrative order. Not that the institutions or organizations are afraid of that, but a balance has to be struck. It was struck, but there can't be a shoot at sight order.
The ecological balance that we've achieved, Milord, has been after a lot of efforts
We
by
appreciate your
officers,
efforts.
Milord. Yes.
We do appreciate your effort.
Obliged.
Item 12.
Item number 12. Yes.
My lord, the matter pertains to my lord supply and procurement of materials for my lord construction of various works. My lord, repairing.
कौन से आइटम में बहस कर रहे हैं वो? No. कौन से आइटम में बहस कर रहे हैं?
Item 12.
Item number 12 has been called out. हाँ तो बहुत देर है अभी. Yes.
May I please, Lord? Item 12, I am appealing for Revenue Department. Lord, against the same order, we have also prepared an appeal. That matter is listed on Monday, Lord. That matter is listed on Monday, Lord.
Can you be slightly slow in saying? I mean, I just can't. There has to be limited number of words per second per minute. No, you speak like this. How will I know what I say?
Against the order.
Against the same
order.
judgment.
Lord, we have also prepared an appeal.
You are who?
Revenue Department. Lord.
Okay. You have also preferred an appeal. Where is that appeal pending?
Lordship, it is listed on Monday, Lordship.
In our court.
Lordship.
Can you give us the name?
Lordship.
Number.
Lordship. IS civil number 580. Delay is there, Lordship.
Delay देखेंगे.
It is not number, Lordship.
Suppose we don't condone the delay, then what appeal? You want to respond here, which is all right.
Maybe taken up together. Maybe taken up together.
No, it may be taken up, it may not be taken up, or it shall be taken up now. We will ask you. The moment you say this, we'll ask you, what is your cause of action? Tell us what aggrieves you. Tell me.
Yes, Lord.
We were granting him time. Why did you say it may be done? We don't require your approval. No. Now you argue.
Lordship, we have filed this writ appeal for the enhancement of the compensation amount, Lordship.
After 44 years.
Yes, Lordship.
After 44 years.
Yes, after
तो अभी
44
क्यों नहीं डिसमिस कर दें आपकी अपील?
after 44 years.
अभी क्यों नहीं डिसमिस कर दें आपकी अपील विदाउट हिज ऑब्जेक्शन?
Solitium was not given to
यहाँ
us.
केस कमजोर हो, वहां जब टाइम हो रहा हो तो चले जाना चाहिए. आज ज्यादा एडवेंचरिज्म नहीं ठीक है. देखिए मिस्टर सो मिस्टर Mr. S. Datta, Learned Counsel for the Revenue Department submits that he shall respond to the memo of appeal by the next day. Re-notify so and so day. That your appeal, the delay of how many days?
240 days.
So we may not condemn. So you contest this.
Let's it.
23rd March. Item 13.
Mr. Sharma,
Lordship.
I also remember, and my brother has just reminded me, we are dealing with these flash floods because of illegal, mining and cutting of hills and all that.
Yes.
And there is a project which is coming up with Norway's company, or maybe some Norwegian company, and the Advocate General has looked into the matter. There's a report by an authority. Can we put it along with that?
Lordship.
I think you'll have a broader base to argue.
Yes, my lord. In fact, my lord, the petitioner, they have put forward some suggestions.
Let this PIL be listed along with, can you give us that PIL number, Mr. Nath?
I'll just,
You remember when Mr. Ken Chaudhary was appearing, he had given a plan by engaging the services of some private, methodologist,
my colleague has given the name. I'll just give the number.
place this along with so and so on so and so day.
But otherwise,
Robin, take the order. Let this PIL, which deals with deals with severe recurring artificial flash floods and waterlogging in many localities of Gauhati, be listed along with so and so. Now, name and number to be provided. Likhna mat, name and number to be provided.
In fact, my lord, I have got an interim prayer. In this case, my lord, the government is now planning a culvert. In fact, NIT has been issued. I have enclosed, my lord.
You want to stop that?
Till the next date, my lord. Because
Culvert is not going to disturb.
my instruction is, my lord, 50% is already done.
Just a minute.
Lordship.
Whether it is done or not done, culvert is only for the benefit of people crossing that, or for allowing the rainwater to cross through.
No,
Why would we stop it?
That culvert will be again connected to that area, my lord, that Anil Nagar area.
It doesn't matter. Let's see. No interim in all that. Such businesses are best left to the administration unless you say that they are not doing it. You should have come with a prayer that they are not doing it fast enough. Culvert has to be made, no? Yes.
Well, the PIL number is PIL 14 of 2024.
Yes. 14.
14. PIL 14 of 2024.
And what is the next date there?
Northeast Eco Development Society. That is they are the petitioner.
It is the next date is
Date to date.
Yes.
Date to date. Date to date.
Date can you give? Anyway, he'll find out. Next. We'll get a provide. We'll come back in 5 minutes. These are too vague PILs. You respond.
My lord.
You respond to this, but it's very vague. It can be dealt with even today without any response. But then you have raised some issue of corruption. We'll see. Let response affidavit on behalf of the respondents be filed by the next date. Re-notify also. SLE, just a minute. This is this public interest litigation. Flags large-scale irregularities and corruption, including misappropriation of public funds under the Manrega scheme in Chongkham Circle, Namsai District, Arunachal Pradesh. It has been alleged that the construction, extension, repairing, and maintenance work has not been done properly, and it is largely because of misappropriation of funds in that account. These works, the allegation relates to these works during financial years 2019, 20 to 2023-24. The majority of the non-wage component has been misappropriated through fraudulent practices. Inflated bills and challans have been paid by chosen few firms and suppliers, like response numbers 8 to 10. Without verifying whether the supplies were made at that, whether the supplies were made, comma, the government authorities have released payments to such suppliers. Mr. Chandran, learned advocate for the state of Arunachal Pradesh, to respond to the aforesaid petition by the next date. Re-notify 6 weeks.
4th of May, 4/5.
My lord. Obliged.
Item 16.
My lord, 15, my lord, identical, my lord. 15.
Same.
Yes.
No, can't be same. This
My
is
lord,
what.
same, my lord, that was
Useless.
15, my lord. Only that is, my lord, under PWD.
Construction in what? Manrega?
Yes, PWD, my lord.
PWD.
Love, लिखना पड़ेगा. The learned counsel for the petitioner submits that in the Tezu division, there had been a Tezu division, comma, under project for construction of boundary wall around subdivision office and staff quarters of PWD, Lohit, in the district of Lohit, comma, there have been financial misappropriation and bungling. Specific instances have been given by the petitioner. Mr. Chandran, learned advocate for the state of Assam, shall respond to this petition by the next day. इसी के साथ लगाना है.
Obliged. 4th May, same date.
Obliged.
Item 16.
May I please? My lord, this matter is relating to claim of old pension. And my lordship claim has been rejected by the learned single judge on the ground that I approached earlier before this honorable court, and the honorable court has granted relief under NPS.
There are only two judgments
Lordship.
which say that it would relate back, the appointment or regularization would relate back to the period when the whole, this whole appointment procedure, the recruitment procedure or regularization procedure started.
Yes.
But that is not followed. The thing is that when was the person regularized? When was the employee regularized?
My lord, our High Court lordship division, there is a division bench judgment.
No.
Followed by lordship, honorable Supreme Court judgment.
Can you respond, Mr. Khatnia?
Yes.
See, these are, widows.
Otherwise,
Otherwise, everything is settled.
yes, madam.
Respond to the petition, we'll give it a decent period. Mr. Khatnia, seek some time to respond to this petition. Respond to this appeal. The affidavit must be filed on or before the next day, 6 weeks.
Obliged.
6/5. Item 17.
I was directed to obtain instructions. Well, the lordship grants me a few days' time. I'll place them.
As prayed by Ms. Sharma. Learned counsel. Let this matter come up for consideration next week. On 9.
Deeply applied.
9/3.
You just have to take telephonic instructions.
Well, I have done that. Well, they are, they have been a bit tight.
All right.
Item 18.
Yes. Thank you. An outstanding amount of rupees 8,99,828 towards rental for the accommodation of judicial officers is not being paid. Mr. Hence the writ petition.
My lord, I'll take instruction and sort it out.
Mr.
Friend.
I'll sort it out. Mr. Mahanta, Mr. T.J. Mahanta, learned senior advocate for response number 2 to 6, submits that he shall take instruction in the matter.
I will sort it out.
And then respond by the next day. But our judicial officers have stayed in that house. The rental has been fixed. It doesn't look good.
That's right.
And next time onwards, you will not be able to get accommodation.
My lord, I will sort it out. My lord.
These judicial officers, they try and live in any accommodation which is provided to them, but still you don't pay to the owner. Who will let you?
My lord.
I know the government has to pay, but you have to.
My lord.
You have to initiate, no, Mr. Mahanta?
My lord, definitely.
Much obliged.
4 weeks.
24th April. Item 19.
May I please look? This is actually my covered case, my lord. Kindly see the last page.
Last?
Last page, page number 53. This is a covered case, my lord.
Covered case?
Yes, my lord.
Is it so, Mr. Taluk?
Yes, yes.
There is a perfect. They are taking the Where is the review pending, Mr. Katniar?
Review is pending is here, madam. Review is pending here, madam. And in fact, some of them have filed SLP also, madam.
SLP is something different. Review is something. Now, where review, we will fix the review and then we'll place it along with the review.
Review petition 15 of 2025, madam.
No. Okay, let this writ petition be.
My lord.
Be placed along with review petition number so and so. When is that listed?
It was last listed in the month of January, madam.
On 6/4.
My lord, we need this, actually we are covered by that judgment. We need
Covered is all right, but you will not get the fruits of this judgment. Therefore, we are making it yours will be the case where.
We need to approach the Supreme Court, my lord. We need this order, covered order to approach the Supreme Court, my lord.
Covered. Covered. Take it. In view of the judgment dated.
Yes, my lord.
Obliged.
That is the issue, my lord. Obliged, my lord.
I'll go before Supreme Court and take an order.
Yes, my lord.
Otherwise, they will not pay. Or we will decide, we will dismiss the review, they will start paying.
Yeah.
Item 20.
I am appeared for respondent number 6, my lord. I also filed affidavit, my lord. 2 weeks time can be done.
No, no, no.
Where were you in the morning?
Yes, my
You should have taken time from him.
My lord, 2 weeks is too much, my lord. Let the
What
matter.
is this matter about?
My lord, the matter relates to appointment of a principal of a higher secondary school.
Not
My
2
lord, by virtue of a stay order, my lord, they are enjoying their
No, no,
position.
not 2 weeks.
Let it be 6 on, my lord, 6, my lord.
6.
Yes.
6.
As prayed for. On behalf of respondent number 6, let this matter come up for consideration. 6th of March. Not beyond that.
Yes.
I did for the school selection committee. I will also file an affidavit by Monday.
Please, nobody is stopping you.
Deep level. Explain it. Ah.
Item 21.
It's My lord, your lordship should kindly come to. You.
Who is appearing? Are you appearing? Somebody appearing online here?
Please, my lord. I'm appearing for the respondent corporation,
Yes.
respondent
Yes,
number
all right.
2, 3, and 4.
All right. Yes, Mr.
Yes. If your lordship should kindly come to page 144, my lord.
144.
Yes, in the earlier round of litigation, my lord, because a preliminary inquiry report was relied upon, and therefore, my lord, in the earlier order was interfered with at page 160. Internal page 17 of the judgment.
You have to tell us some facts of the case. I have.
My lord,
I
a
am not
disciplinary proceeding was initiated against the appellant. In that disciplinary proceeding, my lord, prior to the institution of the disciplinary proceeding, there was a preliminary inquiry.
That's right.
Now, it so happened, my lord, I'm not troubling your lordships with the allegations because that is not even the subject matter. Now, my lord, what has happened? That preliminary inquiry report was relied upon by the inquiry officer as well as by the disciplinary authority while imposing punishment in the earlier occasion, which I put to challenge.
No. A preliminary inquiry was held and thereafter a departmental proceeding was initiated.
Yes.
Then what happened?
Then, my lord, while imposing punishment, the preliminary inquiry report was relied upon.
Okay. So that
So
would not
Supreme
have
Court
been
says you can't do because
Supreme Court and all high courts, including your high court said.
Yes. So on that count, my lord, my earlier round of writ petition was allowed. That is at page 160.
It must have been allowed with some modification.
Yeah,
matter would have been remanded.
to go for a de novo inquiry.
For a de novo inquiry.
Actually, de novo means, my lord, without relying upon the inquiry report, something like that. But the word used was de novo.
The word used from the stage of the vulnerability.
Yeah, from the stage of all. That has to be inferred, my lord. Now that part is at page 160.
160.
0. Para 16. Under such circumstances, this court is of the considered view that reliance placed by the inquiry officer upon the preliminary inquiry report conducted earlier by the department is completely contrary to the law postulated by the apex court, and therefore it cannot be accepted to be a correct procedure. The court, upon giving its anxious consideration to the issues involved, as well as having regard to the law laid down by the apex court, page 160, Millard, para 60.
Then thereafter what happened?
Now, Millard, now kindly see this, Millard. The matter is accordingly remanded back to the department with a de novo inquiry against the petitioner. The department will not rely upon the preliminary inquiry report dated so and so, earlier conducted by the department. Petitioner will be treated to be under suspension and will be granted subsistence allowance as per provisions of law, etc., etc. The idea was, my lord, they will conduct an inquiry without relying upon the inquiry report. Now, what the authority did, my lord, they appointed a fresh inquiry officer.
No, that
Fresh inquiry officer.
no,
And whole thing was done afresh.
Are they or something, which is that case which is starts
KR
all
Dev.
discussions.
KR Dev.
KR Dev. Okay.
So that is the point, Miller. That's the only point. How can they go for a fresh inquiry officer? Well, not in case where doctrine of necessity is to be invoked, either the person has been incapacitated or, my lord, he has retired for something or something, then the question may arise.
Where is that order?
Yes.
According you.
Yes, my lord. One
Pursuant
second.
to this.
Yes. Order to that it to Dango Kotha. My lord, the second inquiry report, which your lordships will get at page number 76. Earlier report was by one Otul Mozumdar, Deputy GM. The other new inquiry is by one Sajad Alam at page 76. Inquiry officer order.
Where is that order?
Yes. Of impugn order, Miller. No, before that, if your lordship would kindly come to page 76, the second inquiry report was given to me. The inquiry report starts at page 77, Miller.
No, but why do we get to know this? How, on what considerations of fresh new inquiry officer?
Miller, there is nothing, based on the order of the learned single judge passed.
Where is that order?
That
Use
order
that
is
question,
not
no?
brought on record.
That question.
I'm instructed to submit, Miller, that order has not been given to us.
How is that possible? Who? Yes, Mr.
Yes.
Yes, Mr. Das.
Please, my lord.
Hmm.
My lord, at page number 195.
Where is that order? Whereby you have appointed
a
another,
fresh
it has to
inquiry.
be quashed, no? Or that would be considered whether it has to be quashed or not. Bring it on record.
Yes.
Let them
Bring
bring
it
it
on
on record, my lord. Please.
That order, actually, you're agreed with that.
In fact, my lord, yesterday while going through, I inquired that also, my lord. Then I was given to understand it has not been given.
We will not say anything here for the reason that it would amount to expressing our views over it. So we will just ask you to, Mr. Ken Chaudhary, senior advocate, submits that he would require some time to bring on record the administrative order passed by the respondents in changing the inquiry officer for conducting an inquiry, which was for conducting the de novo inquiry without their de novo inquiry. Let that order be placed on record by way of an affidavit.
Week's time may be given.
Let this matter be placed. Let this matter come up for consideration. After 3 weeks.
2nd April.
My lord, they may also be, we'll try, my lord, because I'm a dismissed man, whether I'll get access.
Mr. Das, ask your management to provide them with a copy.
Yes, yes.
Otherwise,
Please,
we'll
ma'am.
ask you.
Please, my lord.
All right.
Deep level.
Item
My lord,
22.
my presence may be marked.
Your presence shall be noted, Mr. Nishan Das for so and so.
Obliged.
May it please your lordship. Lordship, in this matter, the brief has been recently handed over to my senior, Mr. N.K. Chaudhary, lordship. We have filed our wakalatnama today. Your lordship,
कहाँ पर है? Which is the matter?
Item 22.
Item 22.
What is your name?
R. Gauhati, lordship.
Mr. R. Gauhati, learned advocate, has appeared on behalf of
The
the
sole
sole respondent and submits that he shall be. Mr. R. So and so has learned advocate has appeared on behalf of the sole respondent and submits that he shall be filing his wakalat. Wakalatnama बोलते हैं या वकालत बोलते हैं?
Wakalatnama.
Filing his wakalatnama shortly before the registry. He would also like to respond to the writ petition. Let that be done by the next date. Re-notify so and so.
Lordship, kindly extend the interim order.
In the meantime, the interim order shall continue, if any shall continue.
There is an interim.
29 April.
We have heard MS Rakhi.
29th,
April.
deep level.
Item 23.
Yes.
May it please your lord.
Yes.
This appeal is directed against the Honorable Single Judge's order, lordship. where my claim for regularization was not interfered with, did not find favor by the honorable.
Let us see the impugned judgment.
It's at page 32, it starts, Lordship.
Just a minute, give us 1 minute.
Yes, Lord. Honorable single judge's reasoning is at para 9.
1 second, 1 second, we'll just call upon you. Where is the fault line in this judgment?
Lordship,
a short judgment, but crisp and pithy, which says that your appointment was against a leave vacancy.
Yes,
The appointment was purely temporary and it was liable to be terminated any point of time, assigning no reasons, and it would not entitle you to any right or claim for regularization. These are the 3 grounds which are weighed with the learned single judge.
Yes, Lord.
Where has he gone wrong? Tell us.
Lordship, the honorable single judge went into the question of it being a temporary appointment.
And what other question was he supposed to go into?
Lordship, the
court directing the state to regularize your services.
Lordship, even I have been instructed to say that a similarly situated lady
Instruction is, I mean, whose instruction? What instruction?
Was regular.
Where have you said that in your memo of appeal?
Yes, I have, Lordship. I have put that in.
Have you given instance? Yeah.
Para 5, Lordship, page 5.
Just.
She was promoted to the post of upper divisional assistant.
Leave with it. Sorry, you don't have a case.
And Lordship, she had, by the time this appeal was heard, the repetition was heard, she had put in 21 years, 5 months and 2 days. And
see, Jago, Rajkaran and others will come to your rescue if it is against a sanctioned vacant post. The post is still. See, you are against a leave vacancy.
Yes.
The person who did not join, her services also has been dismissed, dispensed with. And you are still working. So don't, who can direct for regularization?
Since that day,
who can direct for regularization? Tell us.
And Lordship, Bholanath is there. Lordship, the recent judgment.
For the reason, we have heard so and so. We have heard MS Barnali Chaudhary. In Sikla. We have heard MS Barnali Chaudhary assisted by MS in Sinkala. For the reason of the appellant having worked for more than 2 decades against a leave vacancy, with her temporary appointment being absolute, with her appointment being temporary, purely temporary, and liable to be terminated at any point of time without assigning any reason, with a further stipulation that such engagement would not entitle the petitioner with any right of regularization. the claim of the appellant to be regularized was rejected by the learned single judge, and rightly so. There is no reason whatsoever for us to take any different view in this case. The appeal is meritless. For the aforesaid reason, it is dismissed.
Lordship has already passed the order. I just wanted to say, my lord, her salary is due from April 2017 to
Stop. However, parting with
7
this
years.
case, we direct that whatever salary is due to the appellant must be paid to her forthwith.
April
Must
2017,
be paid to her forthwith. Salary due to her.
April 2017 to April 20. Much obliged.
Item 24.
If we give those details, then we have to ask them whether your statement is correct or not, if due. Therefore, we have not said it. Yes.
Much obliged.
At 24.
May please the lordship.
Yes.
My lord, this appeal is directed against the judgment of this single judge rejecting the writ petition. My lord, the actual background of the case is that my lord petitioner was appointed as a constable under CRPF. After completing his initial training at Srinagar, he was undergoing training at Latur, Maharashtra. And at that time, his mother died and he suffered a mental setback. And he was treated in the government medical college in Latur and also subsequently referred to Chennai, Avadi. And his minor mental setback was exaggerated to be a mental depressive order. And ultimately, he has been declared as unfit to retain in service and training in combatant.
Let us see the impugned judgment first.
My lord, my lord. Like at page 71. 71, my lord.
Just a minute. Give us 2 minutes.
My lord.
Siddhar, you should advise your client not to insist for any service. He needs to live.
Well,
He needs to live. He needs to survive. He can't. He's unfit.
my lord,
See, don't get swayed by the expression moderate depressive behavior. That's a major ailment, especially for police, for paramilitary.
my lord,
And you are suffering from, it's not only psychological, it has got something to do with physiological disease also.
my lord,
There is a compression in the neck because of lumbar disc. And that is prohibiting free flow of air in your brains, number one. Number two, you've had some share of bad luck. So
my lord, his that mental depression was a temporary. Subsequently, he treated in Bangalore and Gauhati Medical College, and they have said that he's resumed to.
you have said that Niman says that he is capable of now resuming his duties, but
And
that is a private
opinion,
of course, very reputed.
And my lord, during the course of hearing, my lord, relying on the judgment of the Supreme Court, my lord, state for alternative accommodation.
Considered that is not a principle.
My lord, the learned singles also said that he is not entitled to that protection. My lord, saying that, my lord,
but good for.
my lord, the judgments has not restricted for consideration of the.
Very difficult, sir. You'll be provided with arms and ammunitions. You'll be posted in difficult.
My lord, therefore, my lord,
you can pursue other works. I mean, we are sympathetic towards you. Therefore, yes. Otherwise, we agree by what the learned single just says. Well, I don't think you are in a fit mental state to work. At least your family will have the satisfaction that he is alive. Take your treatment, do something good, do something in the private, open a shop or something. You can't be entrusted with that work. Take that. We have heard Mr. A.R. Shikdar, learned advocate for the appellant, and Mr.
B. Decca,
and Mr. B. Decca, learned. You're also CGC.
yes, my
Mr. B. Decca, learned CGC for the respondents. The appellant was recruited as a constable, and while undergoing basic training at the Regional Training Center, Latur, in the year 2014, he had to remain absent because of sickness. Later, it transpired that he was suffering from lumbar disc disease with nerve compression. All efforts were made by the respondent authorities to have him treated at hospitals run by the authorities of the training center. After returning from medical leave, the appellant was found to reflect depressive behavior. He was again referred to psychiatric ward of the training hospital, but situation did not improve. He was diagnosed of major depressive disorder and was put under severe medication. Later, with the evaluation of the petitioner by an expert at the hospital, he was declared to be unfit for training and service as a combatant in armed forces. He was placed in shape 5 bracket P and was recommended for invalidation of his service. Mr. Sikdar, learned counsel for the appellant, has submitted that a minor depression for time being because of the death of the mother of the appellant was blown out of proportion, and some recluse behavior shown by the appellant at some point of time during training was taken as a psychological disorder for invalidating his service. In support of his contention, Mr. Sikdar has pointed out that a very reputed hospital by the name of Nimhans has opined that though the appellant had been suffering from grief disorder, but he was fit to resume his duties. Similar opinion has been rendered by a group of doctors, by a board of doctors of Gauhati Medical College and Hospital. Mr. Sikdar further pointed out that in similar circumstances, the Supreme Court has directed for reconsideration by the employers whether the employee shows an improvement and if not, some alternative arrangement be made. Bracket refer to Ravinder Kumar Dhaliwal and another versus Union of India and others. Bracket judgment dated 17/12/2021, passed in civil appeal number 6924 of 2021. The learned single judge, finding that such depressive behavior is persistent and the appellant still remains under heavy medication, found that it would have been inappropriate to differ with the opinion of the authorities / employer, especially when it concerns service in the paramilitary, where a person has to where an employee / constable has to display a total alacrity of mind and physical agility. In fact, there does not appear to be any, in fact, from the records, as a next paragraph, in fact, from perusal of the records and the manner in which the appellant was subjected to medical treatment while at training at the instance of the authority, there does not appear to be any malafide in invalidating the services of the appellant. So, in fact, such invalidation of service was necessary for saving the life of the appellant, as also to maintain the standard of paramilitary forces. We find no reason to, we find, despite all sympathies for the appellant, no reason to interfere with the judgment passed by the learned single judge. The appeal is dismissed.
Development.
Item 26.
This is an appeal against 11 single judge's order in a land acquisition matter. Where the land for construction of fencing in the India-Bangladesh border in Mizoram was acquired below. There are three fundamental errors.
You can give us 2 minutes.
Yes.
This concerns Lungli district, no?
Lungli, yes. No.
Mr. Lal. Okay, yes, you're prepared, Mr.
Yes.
Zawa? I hope I have pronounced your name correctly.
Yes, yes. Last.
All right, yes.
There are three fundamental errors according to me, Lord. Today,
All right, we resume after lunch.
may I give some facts, Millard, before going to the judgment and the grounds, Millard?
Yes.
One of the draft award was of 22nd April 2009, Millard. And as I said, Millard, this was for acquisition of land for border fencing in Lunglei district that had the border between India and
just
Bangladesh.
give us 2 minutes?
Yes.
Please take your seat. We'll call. Yes. Yes.
There were multiple rounds of litigation in this, Millard. There was a draft award of
made in 2009.
2009, Millard.
Yes, then?
Now, Millard, they filed a reference case under 18, Millard.
Who means respondents?
The respondents, the private respondents. They are about more than 300 in number, Millard, landowners. And a judgment is passed by the reference court, which is of 7th August 2009, Millard, which your lordships will find at page 115. And the learned reference court, Millard, is pleased to grant them at page 123, Millard. I'm just taking your lordship to the operative part. Page 123. The reference court is pleased to grant them 23(1)(a) and 2, Millard. Page 123, Millard, the judgment starts at 115. 123, Millard, the operative part. The claimants noted in the reference application are entitled to statutory benefit provided by 23(1)(a) and 2 of LA Act 1894, and which I award them the said benefit respectively. The district collector Lunglei shall make assessment for necessary payment of the statutory benefit above stated when the claimants counsel for claimants submitted application to the district collector Lunglei for assessment and payment of the said statutory benefit under 23(1)(a) and 2 of LA Act to the claimants noted in the reference application. Hence, with this order and decree, this land acquisition case is disposed accordingly. Now, this was 2009, Millard. They file, when I say they, Millard, actually, I must say that this first LA case was filed by one advocate, Millard. The parties themselves never came before the court. The 2009 reference case. Then yet again, Millard, on 18th September 2014, another advocate files another LA case.
Yes.
Which is rejected on the ground of limitation, Millard. This is dated 18th September 2014. The lordship will find this at page 124 and 126. I'll just read the conclusion, Millard, at page 126. the third sentence. And thus I find that the application under 18 LA Act submitted at this belated stage is barred by limitation as per section 18(2)(a) and (b), and present application stands dismissed. During the hearing of the case, objections were submitted by village council president of villages of the claimants regarding the authenticity of power of attorney submitted by Rupai and Chakma. However, I find this issue need not be considered by this court at this stage. Then, my lord, they file a writ petition. Now, this time, my lord, and this is, my lord, 2016. In 2015, my lord, I must say, they file a writ petition, WPC 2 of 2015, before the Aizol bench, my lord. And this writ petition is again disposed of on 30th of March 2017.
Where is that order?
That order, your lordship, will find at 130. Justice Pathak's order, 130 it starts. It's a short order. May I read it, Lord?
Yes.
Heard so-and-so. Second paragraph. In this writ petition, the petitioners herein prayed for a direction to the respondents to pay compensation to them as awarded by the District Collector, Deputy Commissioner Lunglei in Draft Award 1 of 2009, along with interest and solatium under Section 23(1)(a) and 2 of the Land Acquisition Act, which have already been awarded by the judgment dated 13 July 2009, passed by learned Additional District Judge Lunglei in LA Case 1 of 2009, and for further interest for delayed payment of Draft Award 1 of 2009, and also to quash the proceeding of LA Case 1 of 2014, or to regard the same as non-existent for all purpose. The LA Case 1 had arisen from the Draft Award 1 of 2009 passed by the Deputy Commissioner Lunglei with regard to acquisition of land for Indo-Bangla border fencing at Singur 2, so-and-so. And one, Rupayan Chakma had filed an application under Section 18 of the LA Act before the District Collector on 17th October 2014 on behalf of landowners of the award number 3, 4, and 5 of 2007, 2 and 3 of 2008, and award 1, 2, and 3 of 2009. We are concerned with award 1 of 2009, Miller, passed by Deputy Commissioner Lunglei challenging those awards. On the matter being referred by the District Collector Lunglei in LA Case 1 of 2014, learned District Judge Lunglei found that the said application for reference under 18 was barred by limitation as it was filed on 17th October 2014, whereas the aforesaid awards were passed on so-and-so dates, Miller. Accordingly, the learned reference court, that is learned District Judge Lunglei, by its order dated 18 September 2014, rejected the said reference petition under 18 of LA Act with regard to award number 2, 3, 4, and 5 of 2007, and 2 and 3 of 2008, and 1, 2, and 3 of 2009 of Deputy Commissioners so-and-so. The claimant of said LA Case 1, instead of preferring appropriate application under the law, preferred this writ petition, which is not maintainable. There is a finding rendered that this writ petition is not maintainable. With regard to LA Case 1 of 2009 of the learned Additional District Judge Lunglei, it is seen from the records of the case that the said award, dated 13 July 2009, was passed without issuing summon notice under Section 20B of the LA Act 1894, as amended to the acquiring department, that is EPIL, that is my client, on whose behalf said land was acquired in Award 1 of 2009 by the Deputy Commissioner Lunglei, and as such being an interested person to the extent of determination of acquisition compensation only. Now, no direction can be issued to the said respondent number 5 EPIL for payment of any such compensation determined by the court in said LA Case 1 of 2009 on 13 July 2009. The Honorable Supreme Court in the case of Krish Upaj Mandi versus Ashok Chingai, reported in 91 Supplementary 2 SCC 419, held that the beneficiary, the government-owned company, the body for whose benefit the acquisition is made, is a person interested, and service of notice under 20 of LA Act is to be issued to them, as the burden of payment of compensation is on such body for whom such land has been acquired. It is mandatory for the court of reference to have caused a notice served on the said body before proceeding on to determine the compensation claim. And in the event of non-service of any such notice under Section 20 of the LA Act, it would amount to deprival of an opportunity to place its case before the court, and such non-service would render the judgment in reference not binding on such body for whom land was been acquired under the said Act. In view of the above, this writ petition stands disposed of, directing the District Judge Lunglei to consider the reference application of the applicant's claimants in the LA case so-and-so arising out of Award 1 of 2009 of the District Collector, Deputy Commissioner Lungle, afresh, after issuing due notice under 20B of LA Act to the respondent
Was
number
this
5, that is
challenged?
EPIL. This was not challenged. This is attained finality and this was remanded to the reference court, my lord. And the reference court at page 134 decides the case, my lord, rejecting the case, my lord, saying that a reference has not come from the DC. Therefore, it's not maintainable. 134, my lord, the judgment starts. They had also moved an amendment application in that, my lord, which may be of some relevance later, my lord. But I'll just skip that for the time being. My lord, the 134, it starts in the relevant portion your lordship will find 139 bottom, my lord. Para 11. In a nutshell, although Honorable High Court is vested a writ jurisdiction to entertain and dispose of writ petition claiming interest and solatium under 23 1A and 2 of LA Act, even in the absence of any reference under 18 of the said Act of 1894, as held by Division Bench of Honorable Gauhati High Court, Aizawl Bench in the case of Young Lai Association and State of Mizoram and others. Civil court like this court is not bestowed such similar jurisdiction by law, is the well proposition of law. Moreover, with regard to the proposed amendments as excerpt above principles laid down, I'll skip this, my lord. Para 13, in the above dicta, proposed amendments preferred by the applicants is quite different. The conclusion is, in the backdrop of findings and reasons discussed, this court has no grounds to proceed further, and it's returned under Order 7, Rule 11, my lord. The plaintiff is rejected. Then, my lord, they file yet another writ petition, my lord, in 2018, July 2018, my lord. This is WPC 87 of 2018. Well, the writ petition is starts at page 141, 142, my lord, 142. The prayers, my lord, will find at page 182. My lords have it, 182. Yes. In the premises, it is most humbly prayed that your lordships may graciously be pleased to admit this petition, call for records and issue rule calling upon respondents to show cause as to why they shall not be directed to pay compensation to the petitioners as awarded to them by respondent number 3 Wide Award 1 of 2009, along with interest and solatium in accordance with 23 1A and 2, and further interest for delayed payment of the award 1 of 2009 under 2834. 23 1A and 2, which was already granted in the earlier case by the reference court, plus they also asked for 28 and 34, my lord. Now, my lord, I filed my response.
So let's see the order.
Yes, my lord, I'll just take your lordship to the impugned judgment now at page. My lord, can I just show, because there's a objection that we raised pertaining to, my lord, the acquisition of the land, the area of the land rather. No, we were saying that there's much more area which was acquired under this award, my lord, of which we had no notice, as recorded by the learned single judge in the earlier writ petition. Now, my lord, this is, your lordship may kindly bear in mind that this is only a fencing at the border. So according to us, my lord, and a width of the land need not be more than 18 meters, my lord. That was our case all along, and we had also filed the necessary documents along with our counter affidavit. So we also tried to plead, my lord, unjust enrichment in this case. And of course, my lord, we also argued, and we put it in our written submissions also, that in essence, they are seeking execution, my lord, of the judgment, the reference court's judgment. So the writ petition is not maintainable, therefore. That was also one plea, my lord. And neither of these two pleas, my lord, were addressed by the learned single judge, is my respectful submission. Now, my lord, I'll take your lordship to the judgment. Just before that, one order, page 242, my lord, of the learned single judge. That's an order dated 7th March 22. 242. In fact, before that, page 220, I'm sorry, my lord, I'm taking 220. This is an order passed. Page 220, my lord. Two orders I would like to show before the final order is passed, my lord. Page 220. Let me just come to the fourth paragraph, page 220. Keeping in view the stand taken by R5 in the affidavit, the Deputy Commissioner Lungle shall submit an affidavit stating the total area of land acquired by state in pursuance to draft award 1 of 2009. The area acquired shall be mentioned in the form of square feet and square meter. The Deputy Commissioner Lungle shall also state as to whether there is any Government of India guideline with regard to area of land to be acquired for the purpose of border fencing. The above is required as the border fencing works would involve usage of a limited area of land only, and it may not be in public interest to acquire more than what is required for border fencing. The Deputy Commissioner shall also state the exact area of land acquired from each of the landholders. A copy of this order be furnished to so-and-so. An affidavit is filed on the next page where they admit that they did not adhere to any guidelines. There are no guidelines, is what they said, for the acquisition. Then, my lord, there's another order of at page 242 in the same writ petition, my lord. 7th of March 22. After hearing the learned counsels appearing for rival parties to some extent, it appears that a perusal of the original records of draft award 1 of 2009 dated so-and-so for an amount of so-and-so is required to be perused by this court. Accordingly, Miss so-and-so appearing for so-and-so shall produce the original records by the next date. Then next order, page 244 also. Although this court-wide order dated so-and-so had requisitioned the original records of draft award number so-and-so, the records produced by the learned government advocate today comprises only of the list of landowners and the calculations made. What the court would like to peruse is the entire original records, which would include the award itself and including the various notifications issued under the Land Acquisition Act so-and-so. The reason I've showed your lordship these orders is that the court definitely wanted to see the records because there was a genuine apprehension, my lord, I would say, my lord, a genuine apprehension that, my lord, land that was sought to be acquired was much, much more than what was really necessary for, my lord, just a fencing across the border. Now, my lord, the impugned order starts at page 245. 246, my lord, the judgment commences. My lord, the facts are discussed from paragraph 5 to paragraph 8, my lord. The submissions are recorded, my lord, of the respondents with the petitioners at paragraph 10 and 11. Lord, our submission 10, 11, and 12, our submissions are recorded at paragraph 13, 14, my lord, and 15. Now, my lord, paragraph 13 at page 255, I would like to refer, where we had taken the plea, my lord.
Yes.
That in essence, my lord, this is only seeking execution of the judgment, the award, my lord. At the very top of the page, my lord. On remand, the reference case was dismissed by learned LA judge, and therefore the petitioners cannot claim enforcement of the award number so-and-so and for payment of interest and so-and-so. I've taken a more specific plea on maintainability, which I'll show from my written submissions, my lord. Regarding the width also, there is the learned single judge records it at page 255 itself. He submits that the award does not indicate the area and nature. My lords have it. Area and nature of the land holdings, and that the area taken for calculating compensation is not as per the norms of land acquisition for border fencing. He submits that the general norms for acquisition of land for border fencing is around 8 feet to 10 feet in width, or 2.43 to 3.08 meters in width. Likewise, acquisition of lands for border road is around 11 feet to 12 feet in width, or 3.35 meters to 3.65 meters in width. Thus, in all, the width of land to be acquired for border fencing plus border roads comes to around 22 feet or 6.70 meters. Now, my lord, I'll just pause here for a moment and to show the document, my lord, which we relied upon in our counter affidavit to show the width of the land which is necessary, my lord.
What is yours? We have followed, Mr. Putin, we have followed what this. Now, anything else that you?
Yes, yes, my lord, page 197. This is what we relied upon, my lord.
You formulate your arguments, no?
Yes, no, my lord, what, these are the documents, which reflect that the measurement of the land lands rather, which were being acquired for this border fencing, my lord, the width was never more than 18 meters. So we had produced material on record, which the learned single judge does not refer to, my lord.
And what is the reasoning given by him?
My lord?
What is the reasoning given by him?
No, this issue is not dealt with at all. The reasoning or other, I mean, what he says is that the award.
Yes.
And Willard, I had taken a specific plea. This was the width. For the width, I'm referring to page 196, 197, Willard, of the paper book, where the width is clearly mentioned. If I can show that, Willard, page 196. Yes, yes, Willard. And
You've taken that plea, it was not referred.
I have.
You've taken that plea,
Yes.
that was not addressed.
Willard,
With respect to the width, you say it is only 18 meters. They have made they have treated for compensation for 50 meters.
it goes, Willard, from 150 to 500 meters radius is what the award says, Willard. 150 to 500 meters.
Yes.
Willard, and then one plea on maintainability of the writ petition. On maintainability of the writ petition, Willard, because this hearing was happening during the.
Yes, Mr.
Willard, just one more aspect, Willard. On maintainability of the writ petition, there's a specific plea we took, Willard, in the written submissions, because this hearing was going on during the pandemic, Willard, through VC. So we had filed the written submissions, and Willard, there we had taken a specific plea that the maintainability of the writ petition is itself a question, because in essence, you're seeking execution of the judgment of the reference court, Willard, which Willard,
that's a major plank. That's a major plank of argument here.
Yes, and Willard, there are 5 judgments, Willard, of different high courts. Willard, 2 of the Calcutta High Court, 1 of Allahabad High Court, 1 Punjab and Haryana, Willard, and 1, in fact, also of Andhra Pradesh High Court, Willard. All have taken the view that a writ petition would not be maintainable, is not an appropriate forum seeking execution of an award, Willard. So that's a consistent view taken by it.
Give those judgments.
And yes, Willard. And this aspect has not even been addressed by the learned single judge. Lastly, just one more point, Willard. Willard, the learned single judge, according to me, commits a serious error in granting interest from the date of the award. He doesn't say, Willard, date of the award, but what he does in effect, Willard, at page 264.
Yes, Mr. Lalonzo. You give your judgments.
Well, this and on interest also, there are few judgments, where they say that if there is a delay on the part of the landowners in approaching the court,
Yes.
Hello, sir. My learned friend has raised certain fundamental issues, such as the land acquired is much bigger than what is required for the purpose of construction of the border fencing and road, and that the judicial orders passed in connection with the earlier cases were not taken into consideration, and that there was a much delay in approaching this honorable court. In that, Lordship, I'd like to take Lordships to the fact that award number 1 of 2009 was passed by the competent authority.
Yes.
And immediately thereafter, without being asked by the petitioners, a case was filed. A case was filed for reference by Srimati Buang Thangpui, advocate, on behalf of all the landowners. It appears that she had filed on behalf of all the landowners, as can be seen at page 115, Your Lordship.
I think we will hear it up. You give your judgments. Give your judgments, and you also give your notes of argument. We'll hear it. We'll fix it for hearing. Has this appeal been admitted?
Not admitted, my lord, but my lords were pleased to grant the stay, my lord.
Let it remain in the admission stage so that Lordship it may be taken up.
What?
Second May 2025, my lord was pleased to grant a stay, my lord. Initially, there was a question of service because there were many respondents. My lord.
Let the state and we'll decide it. So we'll keep it for hearing and we'll fix a date with prior. Yes. In the meantime, please give your notes and compilation.
Yes,
and you too. Get this matter, this under that because the heading stay. I'll continue in the meanwhile. Let this case come up under the heading hearing in priority on. Mr. Lalram, when would it be convenient for you? We'll keep it as item number first. Today.
The month, sometime in the month of March.
Not in the month of March. March would be
After Bureau.
After Bureau, when where is 19th? You're pending. You can ask for a date from 20th to 24th.
24th,
24th. In priority. In any case, on 24th, we'll hear and complete.
All right.
In the meantime, you give your statement.
You may mention that in the order.
When will you give that?
2 weeks.
It will not take 2 weeks.
We'll file it a week in advance.
Oh, that we are not stating.
No difficulty.
You do it in one.
Lordship, I have given the
You have a
brief, yes, synopsis of my organ.
Item 27 and 28.
This one.
Yes, please. This is in regard to your lordship.
Have we said anything? What is the clearance still?
Lordship, as of now, they have de-reserved the Garbhanga Wildlife Sanctuary. That is without the approval of the
What is
National
this? What
Board.
is the judgment of Supreme Court that you have placed on record?
Yes, your lordship. Lordship will kindly take up my reply affidavit.
No, what is the issue? First, you tell us. We are not aware of this.
Yes. Lord-
Give us 2 minutes and then we'll ask you.
Lordship.
Mr. Goswami, you're appearing for which party?
Statement.
State. Now, who appears for the forest department?
I
Who
appear.
appears for railways?
I appear for forest.
You appear for forest. Who appears for railways?
Railway is not there.
Mr. Tabildar, what has happened to that survey of putting a railway track through Darbhanga?
Yes. Today I am appearing on behalf of RJP, the under treatment at Kolkata. He is appearing railway for railway. And as per the telephonic instruction policy, the railway had conducted a survey through drone lordship or single line lordship railway track. But that is that was started and that's stopped there.
No further survey also has been done.
Nothing.
Now, what is the status of this cancellation? I mean, it remains cancelled. It is no longer a forest, reserve forest.
No, that is what they have wrongly projected. It's a reserve forest. It's a reserve forest. Government intended to declare it as a wildlife sanctuary under the Wildlife Protection Act. For that, my lord, preliminary notification was issued. When we proceed further, my lord, we faced with certain difficulties, like Forest Rights Act comes in, my lord. There are several villages. We decided we will not declare it as a wildlife sanctuary. It will remain as a reserve forest, my lord. They say we have de-reserved. We have not de-reserved. Initially, as per section
Where have you said so in your application?
Yes, my lord. Item PL 66 of 2022. The affidavit.
PL 66, yes.
Yes, affidavit filed by respondent number 3.
Page?
Page will be, my lord, 135. Just background facts for para 4.
Just a minute. What are the background facts? Just tell us again.
135, paragraph 4, my lord.
Read.
At the outset, it is most humbly submitted that the Gauhati Reserve Forest was notified in the year 1926 by notification of Government of Assam, number so and so, having an area of so and so hectares. Further, the first addition to Gauhati Reserve Forest was notified by Government, notification number so and so, having an area of so and so. The Rani Reserve Forest was notified in 1882 by Government, notification number so and so, dated so and so. The Gauhati city lies, para 5, lies immediately in the north of the reserve forest, and the southern part of the reserve forest constitutes the interstate border of Assam and Meghalaya. It is most humbly submitted that there are 6 villages, settlements of citizens belonging to Khasi and Garo communities inside the Gauhati Reserve Forest that existed prior to independence, and the same is mentioned in the notification of Gauhati Reserve Forest. These settlements in the course of time have expanded almost 3/4 of the Gauhati Reserve Forest with extensive jhum cultivation every year. The Government of Assam had issued a preliminary notification declaring its intention to notify these tracts as wildlife sanctuary by EFC number so and so. This is the notification. It is pertinent to mention that the aforesaid preliminary notification dated 28/3/2022 issued by the government of Assam did not alter the legal status of Gauhati Reserve Forest, which continues to be a reserve forest in view of the aforesaid previous notifications dated so and so, so and so, and so and so, which shall continue to be in force. So if my lord now peruses paragraph 10, my lord.
No, let's see what is 18A.
Look, my humble submission, some mistakes were done by the government, my lord. There cannot be a section 18 notification, intention notification. It has to be under section 26A.
What is from 18A? First we
18A says, my lord, 18A, protection of sanctuaries. When the state government declares its intention under subsection 1 of section 18 to constitute any area not comprised within any reserve forest or territorial waters under that subsection as a sanctuary, the provisions of section 27 to 33, both inclusive, shall come into effect forthwith. Till such time as the rights of the affected persons are finally settled under section 19 to 24, both inclusive, the state government shall make alternate arrangements requiring for making available food, fodder, and other forest produce to the persons affected in terms of their rights as per the government records. It is evident from aforesaid section that the provisions of section 27 to 33 of the Wildlife Protection of 1972 will not apply to most of the areas under Gauhati and Rani Reserve Forest, as these are already notified reserve forest. So what they have done, government has done, my lord, a notification ought to have been issued under section 26A, my lord. Because section 26A speaks about notifying a reserve forest as a wildlife sanctuary. Here it was already a reserve forest. This section 18 excludes the reserve forest, my lord. So that notification was wrongly.
You have withdrawn and issued a notification.
No, we have cancelled that because it is difficult for us to declare it as a wildlife sanctuary. That is where they are affected. We are not re-reserving the reserve forest. Forest will remain. We intended to give it a more better.
If it is not a sanctuary and if it is a reserve forest,
my lord,
then railway track could cross through it.
No. For that, my lord, Forest Conservation Act Section 2 will come in, my lord. Non-forest activity, they have to take contact.
That survey stops.
Yes,
Otherwise,
railway
whether it is a reserve forest or a sanctuary.
It's a reserve forest now, my lord. It was never a sanctuary. It was intended to be.
Whether it is a sanctuary or a reserve forest, no train line can pass.
No train, unless, my lord, concurrence taken under Section 2 of Forest Conservation Act.
So that they have not taken.
That they have not
so
taken.
They say that they were only surveying it.
Yes.
We are looking at it from the perspective
I understand.
of communication.
I understand.
And necessity and keeping all, cover for the elephant corridor and not to damage. Because all these railway tracks and electrification, that will be done by rubber sheeting.
There are so many accidents causing death of elephants, my lord. Even once, my lord, Forest Department.
They propose some elevated kind of.
Yes, for that, my lord, state has very minimum role. It is to be done through the concurrence of the central government.
I think your grievance would be redressed with this new
elevated line.
Lordship, they have already declared the wildlife sanctuary.
No, intention to declare.
The impure notification is there, Lordship.
Statement given by him on the affidavit.
Lordship will kindly take up the impure notification, your Lordship. That is at in PIL 28, your Lordship.
Where is it?
It's a page
90.
Page 41.
Page?
Lordship, I'm sorry. Page 26 of PIL 62, your Lordship. 62. Is item number 28. Page 26, annexure A.
Yes.
26. Preliminary notification dated 28 March 2021. 2022, your lordship, sorry. In exercise of the powers conferred under section 18, subsection 1 and subsection 2 of the Wildlife Protection Act 1972, as amended up to date, the Governor of Assam pleased to declare its intention to constitute the land described in the schedule annexed hereto as Garbhanga Wildlife Sanctuary. The Governor of Assam further hereby appoints the Deputy Commissioner of Kamrup Metropolitan District to act as collector under the Wildlife Protection Act 1972 under section 18B of the Wildlife Protection Act 1972 to inquire and determine the existence, nature, and extent of rights of any people in or over the land comprised within the limit described in the schedule below.
That's right. So what is bad about it?
Yes. So, Lordship, what has happened? Garbhanga Reserve Forest and Rani Reserve Forest, the rights have already been settled, your Lordship, because they were declared long time back.
We are not concerned with the rights.
Yes,
we are first concerned with the notification.
Yes.
So with this notification in question,
Lordship,
they say that they would like to go for Wildlife Protection Act 1972.
They have declared it as a,
They would
it's a
like
preliminary
to,
notice.
intention to make it into a, to make it as a Garbhanga Wildlife Sanctuary.
It's declared, Your Lordship, under the preliminary notification. So once the preliminary notification is issued, Your Lordship, 26.
Yes, sir, you are reading something else into it. In exercise of the powers conferred under so and so.
Yes, Your Lordship.
It is amended. The governor of Assam is pleased to declare its intention to constitute so. But the whole thing is wrong because 18.1, 18.2 are not the enabling provision for doing it. It is already a reserve forest. Only for sanctuary. It is a reserve forest.
Yes.
So this intention, this preliminary intention is there.
Now, Your Lordship, 26.
What is the sequel notification which you have come up with, Mr.
Then Your Lordship, Cabinet
Page 41. Page 40.
in this matter.
Page 41.
This is impugn also, my Lord.
Read that.
In pursuance of the cabinet meeting held on 25/8/2023, file number so and so, the governor of Assam is pleased to cancel the preliminary notification on Garbhanga Wildlife Sanctuary issued on so and so with immediate effect. So it never culminated into a full-fledged. Lordship will kindly take up my reply if it.
But
just one aspect I would like
minute,
to show you about.
we are trying to understand from you.
Yes,
We are not shutting you out.
Lordship.
Now, question is that you are concerned about the rights of these Jhum cultivators of earlier settlers in the reserve forest.
No, not at all. Your Lord.
What are you thinking?
What I am on, Your Lordship, is they cannot denotify the wildlife sanctuary notification without approval of the National Board and the leave of
Where was the notification?
leave of the apex court, Your Lord.
Where was that notification making it a wildlife sanctuary?
This is the preliminary notification under Section 18, Your
It's
Lordship.
only for the survey.
Lordship, if I may just show one apex care order which I have annexed, Your Lordship, that is in my reply affidavit,
They
Your
go
Lordship.
through it. So let us see that because as it is,
Yes,
they
sir.
have to come under a different provision.
Lordship, this is the same order that has been passed in Kobitara Wildlife Sanctuary. I have annexed in my reply affidavit, Your Lordship, dated 4/8/2025, Your Lordship. If Your Lordship will kindly take up two paragraphs,
The current status, Mr. Goswami, is that it remains a reserve forest.
Reserve forest.
It will always remain a reserve forest.
Once it
Question
is
of
declared
de-reserving
under as a wildlife sanctuary, Your Lordship, they cannot de-reserve unless, Your
Which
Lordship,
provision says so?
26A, Your Lordship, of the Wildlife Protection Act, as well as there is an apex code order, Your Lordship, not to de-reserve any wildlife sanctuary, Your Lordship.
Yes.
And that is upheld in the 2023 order, which I have annexed in my affidavit in reply, Your Lordship.
Come, let us go to the relevant provision.
Yes, Your Lordship. Your Lordship first takes up Section 18, Your Lordship. That is, my learned friend has already.
Yes, with section 26
26A, Your Lordship,
of at what
of the Wildlife Protection Act 1972, Your Lord. Lordship have it.
Yes.
26A, declaration of area as sanctuary, subsection 1. When a notification has been issued under section 18 and the period for preferring claims have elapsed and all claims, if any, made in relation to any land in an area intended to be declared as a sanctuary have been disposed of by the state government, or B, Your Lordship, any area comprised within any reserve forest or any part of the territorial waters which is considered by the state government to be adequate ecological, faunal, floral, geomorphological, natural, or zoological significance for the purpose of protecting, propagating, or developing wildlife or its environment is to be included in a sanctuary, the state government shall issue a notification specifying the limits of the area which shall be comprised within the sanctuary and declare that the said area shall be a sanctuary on and from such date as may be specified in the notification, Your Lordship. Now, 26.
There is no prescription. It's a preliminary notification. They have not. Where is that prescription?
Lordship.
Where is that limiting power?
Lordship,
that once you express your intention, you can't do it.
Yes, Your Lordship. Lordship, that's why I wanted to show Your Lordship this order, which is I have annexed in my affidavit in reply, Your Lordship.
The statute, and thereafter we
Lordship will
We
kindly
will be
see.
able to see their design.
Yes, yes,
if
20
it exists.
Yes,
there.
26A3, your Lordship will come to subsection 3.
Hmm.
No alteration of the boundaries of a sanctuary shall be made by the state government except on a recommendation of the national board.
This stage has not come, no.
Lordship, in their case,
Has there been a notification of the sanctuary?
yes, your Lordship, this is the impure notification which is
If you
there.
don't understand what we are talking, then you just say yes and no. That is not going to help us. In fact, you are helping us
Lordship,
try and understand. Please
Lordship,
don't. We are not looking at you
Lordship.
like a party who is asking for a relief. No, no, no. This is a preliminary notification which you pointed out.
Yes, your Lord.
It was for the purposes of doing it, but the enabling provision was wrongly stated. Now, if they have just taken a cabinet decision to cancel that preliminary notification, they did not specify that they will come out with a notification under the appropriate provision. That they don't say. And perhaps their intention is wrong. But then how do you say that it cannot be before it has been done? Can you, it's a mandate. Protection of forest is a mandate under directive principles of state policy. Correct. So they have to, if it's a sanctuary, it was once intended, it was not done. But where was the sanctuary made? By what notification was it made?
Lordship,
Then only you will come to 26A3.
Lordship, the difficulty is less in their case because, your Lordship, when they've included 2 reserve forests in the sanctuary, the rights of the people have been already settled in those 2 reserve forests. If there is any.
You're getting that.
Yeah.
Please read section 18.
Lordship.
You dispute that it is a reserve, not a reserve forest, it's a reserve forest. You don't dispute that Garbhanga is a reserve forest.
Lordship.
So under section 18, there cannot be any notification including Garbhanga because it excludes reserve forest. Any other except reserve forest.
All you can say is not by way of a statute, but you say the intention is writ large. They have withdrawn this preliminary notification without specifying that it will be issued again under the correct provision under 26.
Lordship, if I may just show one aspect, your Lordship.
No, we'll go to all aspects. Please tell us whether
Yes.
a reserve forest can be notified as a sanctuary under section 18. Please tell us. Then we'll go to others.
Lordship, the initial preliminary notification has to be issued under section 18, your Lordship.
No, it's repeated.
Yes. The state government may by notification declare its intention to constitute any area
Any area
other than an area
comprised within the reserve forest.
Lordship.
So they
Other takes out.
takes out.
Yes, so your Lordship, it
Read
is.
it again, please.
Yes, sir.
For our satisfaction, your satisfaction.
Yes, sir. The state government may by notification declare its intention to constitute any area other than an area comprised within any reserve forest or territorial waters as a sanctuary. If it considered as such area of adequate ecological, faunal, floral, geomorphological, natural or zoological significance for the purpose of protecting, propagating or developing wildlife or its environment. Subsection 2. The notification referred to in subsection 1 shall specify as nearly as possible the situation and limits of such area. Yes.
This notification ought to have been under section 26
AB.
substance B.
26AB.
26AB.
Then, my lord, we would have been bound to follow it because in that situation, my lord, the concurrence from national
We'll
board.
come to you.
Sorry.
Sorry.
Now, after you have read 18
Yes, your Lord.
and all the explanation, come to 18A.
Yeah. When the state government declares its intention under subsection 1 of section 18 to constitute any area not comprised within any reserve forest or territorial waters under the subsection as a sanctuary, the provision of section 27 to 33A, both inclusive, shall come into effect forthwith.
Now come to 27. Better. The declaration of intent, no, 27.
Yes, restriction on entry, your Lord. Now, this is your Lordship in
1
regard.
second, sir. Let us
Lordship.
understand. It shall come into effect. Till such time, next, all right, 33A. Now read 18A2. Merely by expression of an intention. So the finally they have to do what? After settlement of rights, they have to care. And where is the final declaration that it shall be a reserve forest after settling the rights and all?
That is
The protection starts from the very declaration of intention. When does it become a reserve? When does it become a sanctuary? Under which section does it become a sanctuary?
26A. 26A, Your Lordship. 26A.
This is only when a notification is appropriately issued under section 18, not otherwise.
Or Your Lordship, or B, any area comprised within any reserve forest or any part of the territory which is considered by the state government is to be included as a sanctuary. The state government shall issue a notification specifying the limits of the area, which has been done in the impure
So
notification.
this declaration under 26A, has it been done?
That is yet to be done, Your Lordship.
So therefore you argue that.
Yes,
That they have withdrawn it for the purpose of issuing another notification. Now they are not doing it for the purpose that they want to, they want these illegal miners to operate in the area.
Yes.
Which should not be done.
Yes.
Ye baas kariye na. Why
Yes.
do you have to argue something which is not there?
Now, Your
Either
Lordship.
here, not there.
Lordship, the stand of the government is not clear, Your Lordship, because the cabinet decision was taken in a hush-hush manner. That is not before the public, Your Lordship.
Sir, are we disputing all this? What is it?
Lordship.
Mr. Raskwa, perhaps you're not understanding us or we are not appreciating you.
Lordship.
Question is this. Now, this is a preliminary declaration of intention of making it. Now, you have read 18(1),
Lordship.
18 declaration of sanctuary.
Yes, Lord.
You have also read 18A.
Yes.
You have read that with the declaration of the intention only, all the protection becomes operative under 27 to 33. And thereafter, there is a declaration under 26A or B, A or B.
That is Your
So
Lordship.
that declaration is not there. So you can at best say that, well, the government must be asked to declare its intention. What does it want to do? It had expressed its intention. Now, this area would come under 26. Why can't they make it a sanctuary? You have to press it like this.
Lordship.
I think you'll do a better job by pressing this way. I think then in that case, Mr. Goswami will have to explain why they are sitting tight over the matter and not taking further decision.
Lordship will kindly take up one time, my only submission prayer, Your Lordship. I have annexed one order of the apex court, Your Lordship, in my opinion. I just wanted to show the observation of the
Do you
apex.
think we will not go through apex court judgment if it relates to it?
Just one aspect.
Do we
No, not at all, Your Lordship. I bow down, Your Lordship. Not at all.
we ever ignore Supreme Court judgment?
No.
But first tell us about the law and then we'll look at the Supreme Court judgment or its interpretation. Anyway, for your satisfaction, we'll see that.
Lordship. I am obliged, Your Lordship. My affidavit in reply, Your Lordship, dated 24/8/25.
In which matter?
In PIL 62, Your Lordship.
Which is open before us.
Yes, Your Lordship.
Page number?
Page number, Your Lordship. Internal page 35, Your Lordship. Internal page 35.
In the affidavit.
Yes, Your Lordship.
Where is the your affidavit starts from where?
My affidavit in reply is there, Your Lordship, and the internal page, the order starts. This is in the TN Godavarman case, Your Lordship. There was an IA file regarding Pobitara, denotification of Pobitara Wildlife Sanctuary. Okay. Internal page 35, Your Lordship.
You have a pullout of that judgment?
Lordship.
If you have a pullout, give us. We are not finding it yet. You are referring to TN Godavarman.
I file in PIL number 62, Your Lordship. The judgment, Your Lordship. Yes, Lordship. It's in TN Godavarman, Your Lordship.
You're talking about Pavitra and all. So TN Godavarman we have read. What do you want? Which paragraph you want to show us?
Lordship, this is an IA which was filed, interlocutory application, Your Lordship.
Show us from the internal page judgment, 35. Page 35.
Page 35, Your Lordship.
Internal page 35.
Yes,
It runs in 25 pages.
yes, serial number 12, Your Honor, para number 12.
It runs only in 25 pages.
Lordship, the affidavit is dated 4/8/2025.
Mr. Rajkwa, you are some other day. You are making us necessarily. Three things you must tell us.
Lordship.
You have to modify your prayer. Even if you don't modify, we will be asking them. Now, what do they want now? What is their current contemplation? Whether they would go for 26B notification or not. If not, why? Because once they had declared an intention. You proceed accordingly and then you show on this. Think about it. Think about it. Ask us. We are going to. If you don't ask us, we'll do it of our own.
Lordship.
And in that case, we will say that every care should be taken, nothing should be done, no mining, nothing of the kind.
Lordship, may I just show it? I will just.
Which judgment are you referring?
There's an IA which has been filed.
You have to recalibrate your arguments.
Yes,
Now, have you followed what we have said?
Yes, yes. I'm just showing one. Para 12, Your Honor.
Mr. Up till now, I think we have wasted our breath and you have not understood. Pavitra Sanctuary was notified.
It was already.
Pavitra had been notified. They wanted to de-notify. That was not permissible. It is not the situation here. It is still at the inquiet stage of their coming with a proper notification. That contemplation they may have reasons for not pursuing it further. So what they have not made, they cannot withdraw. Well, that is what they have done. They have only said that no, this has been cancelled. Now let them. What does your affidavit say? Forget about 18 and 26.
Yes, yes. We have stated.
Don't talk about 18 and 26.
No.
Tell us what is your intention now.
There are 10 and 11 of my affidavits. Our intention is not to declare again, my lord. With it, that will remain as a reserve forest.
Why?
Let me read, my lord.
But why?
There are certain difficulties, my lord.
What
difficulties I have narrated here, my lord? Just two paragraphs, my lord. That, however, it is pertinent to mention here after that preliminary notification so the DFO West Kamrup East Division has received several objections from local communities residing in and around Gauhati Reserve Forest that their livelihoods are likely to be adversely impacted by the notification. Further, the state government took stock of the land use and the land cover of Garbhanga RF by calling a report from Assam State Space Application Center, Science, Technology and Climate Change Department. On perusal of the map, it has been seen that almost 2/3 of the Garbhanga RF was heavily impacted by June cultivation and the land use change induced by the settlers belonging to indigenous tribal communities.
Mr. If you talk like that, then your forest secretary would be standing on the scaffold.
But there are 908 claims pending.
Now again come back to the act. Because he is pursuing it in a very skewed manner, therefore you are getting all this. Now look at this.
My lord. Section 18, madam.
Just a minute. Now read 18A2. First read 18A and then 18.2. 18A2.
When the state government declares its intention under subsection 1 of section 18 to constitute in any area not comprised within any reserve forest or territorial waters under that subsection as a sanctuary, the provisions of section 27 to 33A, both inclusive, shall come into effect for you. Till such time as the rights of the affected persons are finally settled under section 19 to 24, both inclusive, the state government shall make alternate arrangements required for making available fuel, fodder, and
so this is what the objections which you raised, the inputs that you have got for withdrawing it, that is covered under section 19 to 24.
Yes, madam.
So 19 to 24, the collector has to determine the rights, maybe 2/3, maybe 1/3, but you have to give precedence to ecology, to wildlife, to other things. So these settlements, you can make an alternative arrangement. So you can't just run away from this, only saying that, no, we have not done it, we are withdrawing it, it's only a...
If I may humbly respond to it, madam, that's why I was saying it.
Make a categorical statement that we have recalled this preliminary notification for the reason, not for the reason that it was a different labeling section was introduced, but because we have dropped the idea of making it sanctuary, say that after.
Done.
Then we will consider.
Done. What
And lordship,
if I, my lord,
if I may
kindly
submit
give
one.
me 30 seconds, man. Section 18 comes in when it is not a reserve forest. That means there are persons residing there.
We understand that.
We understand.
So section,
Once
that's
you have
why,
declared an intention, then perhaps his argument, because see, the difficulty with Mr. Rajbhava was that he began differently. That's the whole difficulty.
so my understanding of Wildlife Protection Act is that, my lord, if
Yeah.
we want to declare a wildlife sanctuary in a reserve forest, there is no scope of declaring intention. It has to be directly section 26A2 notice.
Can we understand? Because we are.
Mr. Rajbhava, please forget your argument now.
Exactly.
Let's now deal with it in the manner which will be beneficial for you.
So providing that food and shelter now.
Come to that page where that preliminary notification.
Yes, your lord.
will-
Lordship.
There will be no rights and claims, my lord.
Page 26.
You can't.
Yes, there will be no rights and claims existing in a wildlife reserve forest.
Then without writing anything, we are saying that you don't, why?
I will file an affidavit.
Show us this.
Yes, page 26 is the notification declaring.
Item number 62 you are referring to.
Yes, your lord. Item 60.
62.
Yes,
Preliminary notification.
lordship.
Page 26.
Because they mention
PLC.
a area of 117 square kilometer.
Page 26.
Yes, your lordship.
Half of Gauhati will come under
Annexure
This nearest to this.
half of Gauhati will come under eco-sensitive zone, my lord.
A. That is site specific, your lordship.
Actually, the notification was hurriedly.
So that he also knows
Yes, ma'am.
where does he stand. We
Yes.
also know
Yes, ma'am. Definitely.
where we will not interfere.
Definitely, ma'am.
This is exercise of power. Right.
Yeah.
Thereafter,
Yes, here
Page 41, ma'am.
this notification was for an area of 117 square kilometer.
Cancellation is at 41, ma'am.
And your lordship, the rights of the people were settled. Lordship will kindly come to page 36.
thank you. We have heard the land council from the parties. The government of Assam, exercising its authority under section 18 of the Wildlife Protection Act 1972, issued a preliminary notification on March 28, 2022 to designate an area of approximately 117 square kilometers as Garbhanga Wildlife Sanctuary located in the Kamrup district, Kamrup M district. By virtue of such expression of its intention to declare a wildlife sanctuary in the Garbhanga Reserve Forest, the protection under section sections 27 to 33A of the Wildlife Protection Act 1972 becomes operative. It appears that later, by notification dated 26th of September 2023, the government of Assam and its Environment and Forest Department cancelled the preliminary notification on Garbhanga Wildlife Sanctuary with immediate effect. In the affidavit filed on behalf of the Forest Department, it has been stated that it would be difficult to make a wildlife sanctuary in the Garbhanga region for the reason of large scale settlements of people since times immemorial. What has been questioned in this PIL is that once an expression of intention, once an intention was expressed by way of notification of creating a wildlife sanctuary, it could not have been recalled. Mr. Goswami, learned Additional Advocate General Assam, however, submits that prima facie it appears that the preliminary notification which was issued under Section 18A of the Wildlife Protection Act 1972 was incorrect, as Darbhanga, as the area is already a reserve forest, and for making any wildlife sanctuary out of a reserve forest, the enabling provision would be Section 26
A1B.
Section 26A1B. He therefore submits that though the notification expressing the intention to declare it as a sanctuary was withdrawn, but it was not withdrawn for the purposes of making a correct, it was not withdrawn for the purposes only of coming out with a notification under the appropriate provision of the Wildlife under the Wildlife Protection Act of 1972. The difficulties faced by the government in its forest department is the main consideration. The Land Council for the petitioner, however, with reference to sections 18A,
26A.
just a minute. (18A), 19 to 24. And 26 to 34 submits that the rationale behind dropping the idea of making it a wildlife sanctuary is flawed and is against the principles enshrined in the directive principles of state policy to maintain forests, to maintain forest wealth, and foster biodiversity. This court would like to know from the state in the Department of Assam, in the Department, state in the Department of Environment and Forest, whether the difficulties in making it a wildlife sanctuary, making the area a wildlife sanctuary, is for the reason of resettlement of large number of settlers, or the progress or the intention has been only shelved for a while. Have a full detailed overview. You can't say this.
I will directly.
So on the procedure under Rule 18 are excluded. So
Exactly.
26 one.
Exactly, because they already settled.
This is presumed.
Exactly.
That there is no-
Mr. Rajkot, do you understand?
There is no existing claim.
I got it. I will.
There is no existing claim, it is the presumption. In my understanding, the notification was hurriedly.
Let an appropriate affidavit be filed by Mr. Goswami. Let an appropriate affidavit by a responsible person in the Department of Forests and Environment and Forest be filed by the next state. Re-notify. We are giving you 15. It will be sometimes in the 29th of April.
Right.
5th of May.
My lord, replayable. Obliged.
Up here you say in the affidavit, we'll see. And then we'll see all these judgments of Supreme Court that no, it is not possible. Notwithstanding that, and you would have already done that. The ground that you're taking, you would have already done that under section 19 to 27.
Yes, definitely. When it was notified, it was done.
So
That's
when
why
it
that
was
is not
notified, it was done. So now when you express intention, can you renew?
But there are 908 claims under Forest Rights Act.
Affidavit, you can't take advantage of these.
I will not definitely not take it. 1,000 my lord claims under Forest Rights Act.
And if there
to
are
be decided.
encroachers, you have our backing but you have the statutory backing, you have the legal backing, you
Yes.
can remove them
Yes, ma'am. That is
by
what we are
following the
already doing.
procedure. But then you can't, allow it to be exploited by the people who are close to you.
Never, never. I will never allow, ma'am.
Yes.
Obliged.
Item 30.
और भी मत क्या है कौन तुम
My lord, counsel for a petitioner.
Nobody appears on behalf of the appellant. The counsel for the respondent, Mr. Sharma, the counsel for the respondent is present. List this matter on sometimes in March.
Obliged.
30th March 30.
Obliged.
Supplementary list item 34 for hearing.
Look, that excise matter, just for your lordship's perusal, my instruction, just that, because my lord, the district officers said we are not going for tender, forwarded to commissioner, it is pending before the government.
But no, so many facts come to us, we forget.
Regarding my lord, that
We just remember the faces of the advocate.
regarding the tender, my lord.
It is still on hold.
It is before the government to take a call whether it will be proceeded further or not. Because my lord, this was a decision of the Honorable Chief Minister, so it will be placed before the Honorable Chief Minister. The difficulties will be apprised, my lord, that we are not, it is not difficult, possible to go for, depending upon the call that may be taken by the Chief Minister, my lord.
Mr. Datta,
Well,
you have a choice now.
my lord,
Would you wait for the decision?
Yes,
or
ma'am, that
would
is
you
what-
Wait for the decision,
Yes.
or would you like to have a?
Wait, wait,
my lord, only one thing.
We have given you only two options. You are asking for a third option.
Your lordship is always managing the courtroom proceeding in such a dignified manner. My lord, sometimes we feel whether I should argue or not.
No,
No.
Mr. Datta. You would
This
be
has become a predicament for me.
putting me on back foot, putting both of us on back foot.
No, my lord, I have been observing your lordship is always, both of your lordship is so dignified. So my lord, sometimes we feel.
You know why?
My lord.
If what you're saying is correct, that is because I hear only dignified advocates. Yes.
And the only thing, my lord, I do not know whether I'll be very fair to say that. My lordship will find if the judgment passed by the honorable single judge, if it is required to be interfered, my lord, your lordship will find one order passed by this honorable court.
At this stage, Mr. Datta, there will be some difficulty. Why I tell you? Because another tender pursuant to the judgment was passed.
Well,
That is kept on hold.
yes, yes.
Suppose that also goes. If the chief minister, if that was the chief minister's decision, he says that no, fresh one. So everything goes. Now we can't at this stage say that no, you select him only, because the order passed by the learned single
Yes.
judge was taken not to its logical conclusion, but something was taken ahead. I
Yes.
think that the better option for you would be to await the decision with respect to the next tender for withdrawal or for challenging it. Question. If they say that they will not have an off license now, can we do anything about it?
My lord, of course, it is subject to.
It will be close of the matter.
My lord, yes, your lordship is right, but that will be any decision forthcoming is subject to, my lord, decision taken by the authority under Rule 294A. Well, it's not that the whimsically they can do that. Well, if I take your lordship to that rule,
You're right, 294A has to be there.
my lord.
I think at present, if we do anything, no.
No, my lord,
The difficulty is that you will have to implement those persons.
yes,
who
yes,
participate.
your lordship is very right. But if they take a decision for
Let us wait for them what they do.
my lord,
We adjourn the matter for say 15 days. By
yes,
that time,
yes, yes.
any decision they will take now only, thereafter the code of conduct would come.
Yes.
That's okay, my lord.
After 15 days, maybe we keep it.
15 days, my lord, would be very less, my lord. Everybody is busy, my lord. Nothing will happen.
No, on 8th of April.
My lord.
My lord, can I take your lordship to the order passed by your lordship
Subject
on
to outcome order was there.
on 2/4/2025? My lord, I'll just read this small order. my lord.
Yes, yes.
Mr. C. Sharma Learned Counsel has put in appearance on behalf of respondent number 1. Now, the last para your lordship will find, it is made clear,
Which order are you referring to?
my lord, 2/4/2025. The last para your lordship must see. It is made clear that the proceedings pursuant to the notice binding tender dated so and so plotted by the district commissioner shall remain subject to the final outcome of the writ appeal number 7.
I will see. Without even saying this, it will be subject to the final outcome.
Well, yes,
So we tell us a date of your convenience.
After the vacation, you know.
Then let Mr. Datta say.
after 2 weeks, any day after your lordship.
You want it in March, we can keep it in March.
Yes.
Let this matter come up for question on 26th of March.
March.
Yeah, okay.